Lord, may I leave to mention a matter, my lord? My lord, one writ petition which was disposed of on 4th August 2025. My lordship also dictated the judgment also. Lord, that has not been uploaded.
On 25th July, Lordship, for the clarification. Yes, Lord.
May I have my lords kindly for mentioning stay applications for inclusion, my lord? Grateful, my lord.
Correction of order sheet, correction of order, my
Lord, may we permitted to mention one matter for correction, my lord. Lord, in the order, may I highlight one thing?
For correction, my lord.
The order.
Matter the matter. Why it was dismissed or default? One for my personal, I was in the hospital. First one was Honorable Justice Rajabas Chaudhary. This was called on as the other side court. I immediately came to Mr. Justice Chaudhary Boland, please file one page. Expression, then I so twice. Everything is complete. Minor agreement reply. The Muzumdar is on other side. Exactly. Is the date of hearing. Okay. Yes. Now, back to that, I have filed.
কবে ফাইল করেছেন দর্শক জিজ্ঞেস করেন বলুন ডেটটা বলুন
One file within 1 month. Within a month. And second one was recently. My lord. No one appeared
Twice it has been.
twice. First by your lordship. No, first, secondly by your lordship. First one was just the first two. The second one I was in hospital. I couldn't attend personal difficulty. No one could rather mention before lordship that I was ill. November. Justice Raja Basu Chaudhary. Second time I was in hospital, so I couldn't attend. I traveled, so I person was there in Hyderabad. So it's my fault, man. I couldn't attend because my eye. Now also I am not properly dismissed.
Employees.
Why? The first one, when it was dismissed, I was in other court. I immediately asked to the court and mentioned the before justice. Justice. How many times, my lord? No, my lord, can I keep? No, my lord, no, I was, I think personal difficulty, my lord, I think. So, my lord, can I fix the date? Everything is complete. Evidence are ready. Mr. Majumdar is can I fix the date? More matter.
all the pleadings completed lordship. We have filed the opposition, so they have filed the reply lordship. Dismissal from service lord. ডেট পেশেন্ট টাকা দিন না
দিয়েছে তো সার্ভিস হয়েছে
আমার দিন এখন আবার দিন
এখন দিয়ে আমার একটু অন রেকর্ড সংযুক্ত ভট্টাচার্য previous advocate got died. Subsequently, Mr. Bhattacharya entered. That is the problem. Oh, Mr. Banerjee was there.
Will Banerjee? চুপ করুন না
After death, yes, कुछ नहीं সবাই
দিন দেখি একবার দিন রিট পিটিশনটা একবার দিন রিট পিটিশনটা
না
বুঝুন
একটা দিন
Considering the averments in paragraph 4,
মানে Amol Baran Chatterjee was senior advocate was there. Yes. Yeah. First restoration. Paragraph. Hey. That was there before that, before dismissal. Before dismissal, it had been mentioned. And after filing,
before which court?
it was mentioned.
Which court? Before which court, sir?
That before, I think, before the Justice Raja Basu Chaudhary, that court.
Thereafter? Thereafter, what have you written?
Thereafter, Manor,
Thereafter, what you've written, sir?
when it appeared, the
You cannot
intimation,
write all these things. You cannot simply write all these things on affidavit, which is untrue.
what fact I am telling, Manor?
The applicant states that suddenly upon inquiry, he found that the matter was dismissed for non-prosecution.
My on record was not there. I was in hospital, so I could follow. They should have pursued the matter.
petitioner মানে প্যারাগ্রাফ সেখান ends of justice, let the writ petition be restored to its original file and number. The order dated 23rd of November 2023 as well as 22nd of May 2025 are recalled. Next date be fixed on 29th of August for hearing.
Okay, bros.
Next.
Item number two, my lord. Item 2, my lord, I am appearing on behalf of the appellant, my lord. Claimants of the appellant before your lordship, I have come before your lordship for enhancement. My lord, Mr. Das is appearing in this case. I have already served copy of the paper book upon him. 39 years vegetable vendor expired in the year October 2019. Tribunal below taken, my lord, income 6,000 instead of 8,500, which my claim was that, and 1/4 will be deducted instead of 1/3. Only to this extent, nothing else, my lord. Kindly fixed at any time, my lord.
Just now I got the copy of the paper.
Yes.
Paper book filed by the learned advocate representing the appellant claimant be kept on record. The learned advocate representing the respondent insurance company is present. You want it to be fixed for orders or further hearing?
Let me fix for hearing after 1 week after application.
Next date we fix on 14th of November for further hearing. সেই জন্যই তো আমি বলছি
Firstly, and court, and put the responding last occasion on 17th July 2025, Malat, this was called for because Malat, some documents are not available in the paper book, Malat. It's a case, and then Malat kindly put the matter under the.
PCR এসেছে? What do you want to do? Paper, you want to prepare paper book?
Paper book file, but
Oh, achha, achha.
some documents are not.
No, Lordship, last occasion, Lordship was pleased to call for the TCR. But Lordship, prior to that, there is order for call for TCR, and I have deposited special manager cost. That
PCR has reached the court. Now what is your issue?
issue, Lordship, Lordship,
In the
kindly,
paper book.
Lordship, paper already filed.
Then
Why some documents are not available in the paper book. That is why the TCR
Okay.
is being called for.
No, Lordship,
otherwise it's ready for hearing.
yes, Lordship, the medical document, Lordship want to see the original medical document
Okay.
from the TCR. For the reason, Lordship call for.
Okay. The department has received the TCR from the concerned court of the concerned tribunal. The learned advocate representing both the parties are present. Next date is fixed on 23rd of September for hearing. Next,
Lordship, orders, Lordship. Orders, will.
for hearing, thereafter orders.
Lordship, the Lordship herald the matter. Lordship, I recollect that he had 96%
Now-
disability.
On that date, if time permits, then I'll dispose it.
Okay.
Next,
Item number 5 and 6.
5 and 6, the
appellant.
appeal is disposed of. There's the appeal of the insurance company. Subsequently, Lordship, I found the sole claimant died. So whatever the award passed by your Lordship, Lordship can modify to that extent. I have filed an application by recording the note
when
of death.
the orders are dictated, at that time you are not aware whether the applicant right?
Lordship,
And this is not first case.
Lordship, judgment passed on 24th September 2024, and appellant died on 4th March 2025 after long. After that he died.
Have you received a copy?
I'll wrap.
Go through it and come back at 2 p.m. Whether they are the legal heirs and if the representatives or not,
My lord, I'll come.
you just
Great.
check and come at 2 p.m.
Great.
In this case, my lord, I have found small correction, my lord, at page 3. My lord, only 1 lakh instead of 1,80,000, page 3, my lord.
Interest rate paid 3,64,000.
দেখে যাও পেটটাতে তোমরা এরকম কি করে ভুল করো আমি বুঝি না এই নম্বরটা হবে নেক্সট করে দেবেন আমি
Lordship, there was a direction in this case to deposit within 6 weeks, but since there
that
was a
will be
correction,
extended
must.
next
I can make, my lord, I am appearing on the appellant. There is a delay of 149 days in preparing the appeal, my lord. Stated paragraph 5 to 9, 5 to 9. Yes, 151 days. I have written 151 days.
150 days
Okay, application को भी बीच में
ये देखिए
और पति की ना वो कंपनी के बीच है हमारे बीच में
5 to 9.
to 9
Yes. My lord, there, my lord, I have prepared the paper. Very short question involved in this appeal, my lord. Only income and future prospect, nothing else. I have already my lord, supplied the
filed by the learned advocate representing the appellant claimant serving a copy of the same upon the learned advocate representing
Yes.
the respondent insurance company be kept on record. You have received the copy.
yes, my lord. I have already.
Can it be disposed of?
yes yes
Next date be fixed on
It can be, my lord, with 2 minutes
13th
time.
of November for orders.
13th of November.
And the interesting appeal for the respondent insurance company. There is an appeal for only the issue of interest, but prior to that, I should say, Lordship, there is a delay. Can you condone the delay and Lordship, can you hear the matter on the point of interest, nothing more. Only interest, learned tribunal did not grant it. Learned tribunal granted interest from the evidence as adduced, eyewitness on that day, from the not from the date of filing of the claim application.
407 days.
কি বলবো তুমি?
Wait, Mr. Singh.
ডিলে করে বলবে না অন্য কোনো অপোজিশন দেবে তুমি বেশি কথা বলো না হয়ে গেছে দাও
5 to 8. Yes, tell me.
This appeal is only on the point of interest. Learned tribunal just granted interest from the date of filing, but the date is wrongly typed. Only that typographical error.
So that they could have gone before the tribunal itself.
No, Lordship, not that wrong, but Lordship, I found from learned tribunal awarded interest from the date of evidence of the eyewitness. From the date of eyewitness, only that is the issue. So, Lord, can you dispose of only the interest point?
Today, tomorrow, any day. Only that
No,
date
today I have fixed all your matters for orders.
only
If-
the date is to be corrected. Typographical error.
Wait, sir, let me finish. At 2 p.m., if we can take this matter,
Lordship.
then we'll dispose it. It will be only in a paragraph, right?
Lordship. Grateful to you.
2 p.m.
Number 10, my lord, I am for the appellant. My lord, stay was granted on 1/8/2025. Only a small typographical mistake. The tribunal awarded 6% interest, and in the stay order, it has been given 10%. My lord, the time may be extended. My lord, that is on default clause, my lord. My lord, kindly come to page 8 of the judgment. I'm grateful, my lord.
Lordship,
I am appearing for the CISA. This is my evidence in opposition in respect of section 5 application.
and we are filing the reply.
493 days. My lord. Yes, my lord. My lord, that was restored.
And we have served a copy of the restoration to the opposition.
Restored হয়েছিল তো? Restored হয়েছিল? Oh, no, not to restore, not restored, my lord. Not restored. This is section 5 in respect of the restoration application.
Filed on 21st. May 2025. An urgent matter has been called up in the courtroom. As
No. My lord, no sufficient cause was mentioned, my lord.
restored. This is the last order.
No. Tell them.
458. Because punishment of censure was given and withholding of increment for a period of 2 years.
Initially, censure was awarded against the present petitioner. Thereafter, award was modified, my lord, and the pay was reduced to the lower stage. Reduction of pay to lower stage. He was found with the excess amount, my lord. He took the illegal gratification, this present petitioner. তোমাকে কোন পিটিশনটা দিলাম আমি? Well, it was dismissed on 4th March 2016. Madam, I'm also relying on judgment. Yes, madam. Madam, I'm also relying. Yes, my lord.
Lordship, we will be filing the reply. We have given the opposition.
My lord, in respect of section 5.
We will file the reply.
Yes, my lord. Yes, my lord. Yes, my lord. We will reply to the section 5. Restored. My lord, it was restored, my lord. My lord, can you record my submission, my lord? My lord, I'm relying on judgment, my lord. Can you record that judgment? Judgment. On 2024 SCC online. এটা reported. Fine, কত? 2024 SCC online SC 530. Yes.
My lord, I am for the respondents.
Now, on previous occasion, I have already argued the factual aspect, which has been, my lord, mentioned in the, my lord, the pleading. Their affidavit in opposition, two affidavit in opposition has been filed. One is, my lord, affidavit in opposition, one is additional affidavit in opposition, and the affidavit in reply. In a nutshell, my lord, in the factual aspect, because, my lord, we have already, that matter has been taken up long back. The petitioner has been appointed as an assistant commandant. Subsequently, he has been promoted to the, my lord, deputy commandant. While he was performing the duty of the deputy commandant, he was assigned a duty of an assistant commandant in the bordering areas. Initially, he did not carry out the order in 2 or 3 occasions, and subsequently, my lord, he has been interviewed, and then departmental proceeding has been started. His plea was the direction which was given to him to carry out, that cannot be said to be a lawful command in consonance with the provisions of the BSF Act. So therefore, my lord, he has challenged it before this honorable court by filing this writ petition. When he has filed this writ petition, my lord, he was obtained an order from this court that, my lord, he was pleased to get, honorable court has pleased to pass an order, interim order in his favor, saying that, my lord, although this is prima facie, that this or directions or the instruction cannot be said to be a lawful command. Since he has been promoted to the higher authority, and therefore he should be assigned the job commensurate to his position and the rank, he cannot be ordered for a duty which can demote his position. So, my lord, this order has been passed, interim order, we are enjoying right now also. In the, my lord, by this process, the initial command or initial directions which have been given by the commandant, that has been stayed by this honorable court. Despite staying operation of the said order, there are the, my lord, the successive annual performance report. In the annual performance report, despite there being a restraining order, the respondent authorities has given effect to the content of the said order in all the, my lord, the assessment report of successive years. So therefore, in previous years, prior to this incident, in previous years, his performance was excellent. In all occasions, excellent. And he was having training so that he can combat the Naxalite movement also. So in his entire tenure, he has been posted in the high altitude, but he did not have any difficulty because he is having Naxalite training and he is having gallantry. He is a recipient of the gallantry award also. Subsequently, what happened? Then, my lord, the assessment, all the assessment orders which have been passed, that he has been marked as good, and subsequently he has marked as average without there being any reason. Only it has been stated that he has not complied with the one single order which has been stated by the Honorable High Court. So, in one hand, this writ petition is there. When the writ petition was, my lord, taken up for hearing, subsequently we made an application by annexing all those documents pursuant to the direction of the Justice Rajabasu Chaudhary. On that application, my lord, they have been, my lord, given an opportunity to file their affidavit. They have filed their affidavit and reply also. So once for all, my lord, when this writ petition would be adjudicated, if the writ petition would be adjudicated in my favor, in automatically I would be entitled get all those benefits and the subsequent benefit also. So now, my lord, I have placed it that they
Show me the rules.
yes. BSF Act, right? BSF Act. Section definition section 2R. Two small r. There are three categories of the officers. One is the officers, other is the subordinate officers, beneath the officers, and other is the under officers. So the officers normally appointed who is appointed after qualifying UPSC examination as an assistant commandant, and they would be promoted in the higher ranks. But below that, who have been appointed as a constable, then he has been promoted as an ASI. It starts from ASI to the inspector, that are the subordinate officers. So my case is the officer, that's why we are referring the 2R. Officers means a person appointed by or a pay or as an officer of the force, but does not include the subordinate officer or the under officers.
Yes.
Then the 2V and the 2X defines the subordinate officers and the under officers, although this is not German over here. Then I am referring to Rule 9.
Now the commandant did not have a prerogative to issue any transfer order.
Yes, only the thing is this act is a self-contained code. So to understand the total the scheme of the act, we have to show the provisions and the rules also together. How the power is being emanated, who is the supreme authority, and by which the power is emanated, and how they would be empowered. What is the role of the
Just
commandant?
tell me whether the petitioner was asked to perform certain ancillary duties, or he was asked to specifically and exclusively perform the duties of his junior.
He was, the impugned order says, he has been asked to do a specific duty which is normally being assigned to a assistant commandant, although he has been promoted to the deputy commandant. The plea which has been taken in the affidavit in opposition, there is a shortage of the officers. No document has been disclosed in this regard to substantiate the contention of the pleading which has been reflected in the affidavit in opposition. In Bharat Singh judgment, it has been categorically stated that in a pleading, in a writ petition, pleading will not suffice to substantiate the pleading, because this is on the basis of the affidavits. Since this is on the affidavits, they have to produce certain documents on the relevant point of time, whether the strength of the officers which are normally being available or not.
Responsibilities have been mentioned in the
My lord?
rules, or do you have any regulation, rules, or
Yes, everything is there. Everything is there, my lord. Previously, this pattern was not very structured. While the pattern was not structured in the year of 1997 and 1998, there were certain executive instructions. These executive instructions were issued by the IG level and the additional DG level. For since there is a vacuum, to meet the vacuum, these executive orders are there. Subsequently, in the year of 2003, the entire...
What do you mean by an executive order?
Executive order means that doesn't have any law, that doesn't have any force of law, because this act...
You are saying there had been certain executive orders. So these executive orders, as you are mentioning, comprised of what? The duty chart or the
No,
rules?
only simply direction that the deputy commandant can be given the job of an assistant commandant or any other job. This is the executive order, nothing else. Only two-line order.
So you are challenging the executive order?
Initially, I am challenging the commandant's order, by dint of which I have been assigned to a job of an assistant commandant, demoting my rank. And they have...
You were demoted as an assistant commandant?
No.
Then?
But the job which have been assigned to me, the job...
Was it additional?
No. This was the principal job. Subsequently, when I have requested in twice and the thrice. Then, my lord, I have been given the work of a deputy commandant and the assistant commandant. That is later stage. But in the first order, impugned before your lordship,
So
is
how are
only
you
a principal
prejudiced?
work.
How are you prejudiced?
My lord, if I would not be,
So tell me, how
yes,
are you prejudiced?
my position is this, my lord. When I have been enrolled as an assistant commandant, then, my lord, my principal duty was to guarding the, my lord, the entire area. Thereafter, after 10 or 12 years of seniority, I achieved it as a deputy commandant. When I would be in the deputy commandant, I normally would be posted in the unit. In the unit, there are the 4 sanction posts of the deputy commandant. So if anyone who comes or assistant commandant reports me, if I would be appointed over there, then normally the other assistant I have to work along with the other assistant commandant. In a force, if I have to act with my junior, which is 10 years below, and there would be a complete diminution.
You are still functioning in the same post.
No. My lord, thereafter, I have been promoted as a second in command. Then I have, my lord, tendered my resignation due to the humiliation recently. Because in all the performance report, because this matter of 2007 or something, 2007.
When were you supposed to be superannuated?
Long back, my lord, long back, not the superannuated.
You said you have tendered resignation.
Yes, that is, my lord, in for the month of April this year, my lord.
In April this year, you have tendered your resignation.
Voluntary
But-
resignation.
But when were you otherwise supposed to retire?
Long back, my lord, more than I am 52 or 53, 7, 8 years is remaining left.
7, 8 years are still remaining
Yes,
for your service.
yes. Because I have been,
And
my
you
lord,
have resigned.
due to the only for the humiliation. My lord, I have to work under my junior. And, my lord, the law, provision of the law, just I will refer. If I would be wrong, my lord, I would
This
be
is a
out.
prayer in your petition.
My lord, kindly. My lord, page 22. My lord, may I read out? Page 22 of the writ petition. My lord, got it, my lord? এই রিট পিটিশনটা একটু মারো।
Yes.
A writ in the nature of mandamus commanding the respondent number 6 to forthwith act in accordance with the extant rules following the BSF as per the notification dated 10th of December 2003 and the according to the letter dated 18th of July 2006 and the Deputy Inspector General Border Security for such and such by revoking and the cancelling the unlawful order which was first issued on the 4th of July 2006, a copy of which is annexed such and such. I am seeking for a revocation of the order.
Now
And
you have resigned.
My lord,
Now you have resigned. You have tendered
it will not create any difficulty, my lord, so far adjudicating the matter, my lord, I am giving. Because owing to this, my lord, the illegal order, which they are claiming that this is a lawful command, all the departmental proceeding has been initiated. By dint of the interim order, the departmental proceeding has been kept in abeyance for a long time. Despite that has been kept in abeyance and there is a restraining order, they starting appreciating my lord, all career advancement scheme and APR also, annual performance report. Earmarking my position downgraded like my lord, the average and the good instead of the excellent. So there are, my lord, two-prong attack has been made against me. One is I have not been considered for better posting or I have not been placed normally in the areas where normally being given. In all along, I have been given in the high altitude, which is not done. Normally, my lord, if I have to serve in the high altitude in the 3 years, thereafter I would be given a short posting. That has not been given. All along, I have been given in Jammu. Thereafter, I have been given the Malkangiri.
The rules provide that.
No, does not.
What does the rule say?
Rule says, my lord, the rule position is this. If I have to serve in the, my lord, high altitude area, thereafter, after the giving the 3 years, I have to give an area where I can stay, my lord, comfortably. So this is the normal phenomenon. But, my lord, an individual cannot fight against an entire institution. When the entire institution is passing consecutive orders, how many orders should be challenged? Because in all performance report, my position has been downgraded. So, though I have tendered my resignation, if your lordships hold in my favor, in that event, my lord, this declaration of unlawful order would not be there. Since the unlawful order would not be there, or assessment report, all the assessment years, my lord, the report that would be changed. Because I would be entitled to get all, my lord, ancillary
So
benefits.
just because of this order, your performance report had been
Yes, downgraded each and every year. I have given 5-10 years in my
did that-
affidavit.
was that the reason they had cited
Yes,
for downgrading you?
yes. We have not followed the command of the senior officer. Despite there being an interim order passed by this honorable court staying the order and prima facie holding that this is
So you
cannot be
mean
said
to
to be a
say,
lawful command.
according to them, it had been an insubordination, which you are not ready to accept.
No, they are not saying this is an insubordination. They are saying that
Misconduct. in not
lawful
following-
order has not been carried out. And there is a particular provision 21(2) or something else. The law position is extremely clear. Who can issue it? What is the, my lord, situation? If there is any exigency, how the order would be given? Here it categorically stated in the statute that the command devolves upon downwards. When the commandant would not be there, the DIG will not the work of a commandant. So who will do it? The below this. The second in command would be the officiating commandant. So command will downwards, the rules position is saying so. So even there is a shortage of officer, a deputy commandant would not be assigned a duty of an assistant commandant. Then the inspector will come and officiate the position of an assistant commandant because command devolved upon downwards. It has been stated in the rules position also. So all aspects, all exigency, all eventualities has been taken care of by the rules and the act. By giving a go-by of all the provisions, which I intend to cite, my lord, they passes an order on the strength of an executive order. That executive order has lost its force by dint of the restructuring order. And this restructuring order I have shown to your lordship that in supersession of the earlier circulars, this circular is being issued in the year of 2003. A specific pattern and the structure has been maintained since 2003. Because prior to that, my lord, the limited number of the battalions are there in the entire country. Then in 2003, other battalion has been raised. So a, my lord, scientific category and the staffing pattern has been prepared like this way so that a modalities can be fixed. I am referring all those modalities because this is a 2007. So earlier executive order would not be put in place. Because in supersession of all the earlier circulars of the executive orders, and it has become a law of the land, my lord, whenever there is a rule position is there, the provision of the law cannot be superseded by an executive order. I will rely upon the judgment in that effect also. So my anxiety is this, my lord, despite there being a rule position and the grievance of the writ petitioner which has been reflected in the, my lord, the writ petition, despite there being a specific provision in that regard, a person has
What
been...
was the result of the proceedings?
That has been stayed. The lawful command was not stayed. Lawful command has been held by this honorable court in a prima facie view to be not a lawful command, and therefore the charge sheet was stayed.
Naturally,
Charge sheet was stayed.
lawful command cannot be stayed. Command would
No, you
be-
prayed for
Why
the
did
stay
you
of the lawful
downgrade
command
his performance from year to year, as he is saying?
because there was no order for restoration of his APR. Interim order was limited to the extent of staying of the charge sheet, but not relating to APR. Annual performance appraisal report was never touched in the interim order. So the performance, so the downgradation made in 2007 does not get restored by the interim order of 2008. So that was only carried forward, nothing else.
My lord, the
So how will you assess the performance of a person?
Since it was carried forward from
What was carried forward?
that disobedience of the lawful command.
You mean to say he did not join in that post?
What has happened, I beseech your lordship, is that in a disciplined paramilitary force, anyone should be prepared for any duties. What has been done, this is not a case of demotion. This is a case of service exigency. The rules provide us, empowers the commandant in case of service exigencies to guard the international border by sending any deputy commandant rank officer when there is no assistant commandant or when there is dearth of inspectors. Because one memo was issued by the appropriate authority where it has been said that the inspectors should not be given the charge of company commander in case of exigencies. Naturally, it should be deputed to deputy commandants.
Higher to the inspector.
Yes.
Higher in post to the inspector.
Yes, that was done with him. It was not a case of demotion. He retired as a promoted officer as second in command of the battalion. We have promoted him.
He did not retire. He tendered.
Resigned. Before resignation, he was promoted to second in command of the battalion from deputy commandant. The
Then what
question
about the performance downgradation that he's
that was only carried forward.
that was not given effect.
Nothing.
Paragraph I am
Because,
reading.
sir, if that was given effect to, then you might not have been
Promoted, exactly.
It is not that, my lord. I made a representation against the adverse remark. What is the, my lord, the mentioning? His representation against the adverse remark will be decided after the outcome of the honorable court judgment.
Now that
In
you have
court.
resigned,
my resignation will not affect in any way my lord the position of the writ petition, because if this would be there, the lord the departmental proceeding which has already been initiated, that has been kept in
so
abeyance.
now the departmental
So one aspect is the
proceedings-
departmental proceeding, other aspect is below downgrading my position, all the APRs.
You mean to say you want
In pay
financial
package there would be a
benefits
reflection. In pay package I am not getting
or
many increments and all.
benefits in the finances?
Yes,
I mean
yes.
retirement benefit. I mean
Yes.
the on resignation,
yes,
whatever benefit.
Successive increments. In successive increments.
That was stalled.
Yes.
That has been curtailed to some extent. Well, the question lies whether we are empowered to issue a command to depute an officer as in case of service exigencies or not.
My lord, may I, my lord, place the rule provision, my lord?
Yes.
My lord, rule 9 I am referring.
Yes.
Just a minute. Appointment of the officer. The central government may appoint the such person as it considered to be suitable as the officers in the force. And there, my lord, kindly take a note of it, conditions of service. This is a condition of service. Conditions of the service shall be such as may be provided in the rules and made in this behalf by the central government. So the condition of service cannot be determined by the the DG, commandant or the DIGs. It would be determined by the rules itself, and the rule would be promulgated by the central government. Then, I am referring to Section 141.
Can we just come to the preamble part, sir?
Yes, my
First,
I'm referring to that.
wait.
I'm
The Border Security Force Act 1968. Second September 1968.
Border Security Force was created.
47 of 1968, right? An act to provide for the constitution and regulation of an armed force of the Union for ensuring the security of the borders of India and for matters connected therewith.
Correct.
Be it enacted by Parliament in the 19th year of the Republic of India as follows. The Border Security Force was created towards the end of 1965 when the Director General of Border Security Force was set up in the Ministry of Home Affairs under a senior police officer designated as the Director General of Border Security Force. This force has been charged with the responsibility of ensuring the security of the Indo-Pakistan international border, instilling a sense of security among the people living in the border areas and preventing trans-border crime, smuggling and unauthorized entry into and exit from Indian territory. The force was raised under the Central Reserve Police Act 1949. Now, thereafter, the nature and purpose, etc., etc.
Then, my lord, which
Now, it should be regulated by a separate self-contained statute which will provide for special needs, especially the needs of efficiency and discipline. The present bill seeks to achieve the object. That is a different issue. So, if we go by the intent, so do you think it is a service where your personal objective reigns supreme and more impact and momentum compared to the intent of this act?
my lord, subject to a lordship's current correction, apart from the discipline and apart from the intent,
Maybe they considered your efficiency to be one of the criteria, as you have already stated, that you received excellent gradation in the performance report. So if you had been given the post of deputy commandant, and in addition you had been asked to do certain acts, so can you refuse that? Can you consider that to be your humiliation? What should be the purpose? We are just discussing what should be the purpose when you are in a service like BSF, contrary to any other public service where there is an additional responsibility bestowed on you, not only by the act, by the entire citizenry. I'm just asking you.
my lord. May I be permitted, please?
Rules are there.
Yes.
Rules are saying this.
My lord,
But what does the preamble say?
the preamble cannot be considered in isolation.
That is your answer. That is the answer to your own question, that the preamble cannot be considered in isolation.
Only the thing is this.
You said the preamble cannot be considered in isolation, right? So, as far as the rules are concerned, you have shown me just now rule number 9 as to how the central government may determine the appointment, right? So it can also take the essence of the preamble into consideration.
My lord, may I be permitted to place? May I be permitted to place? Two aspects are there in a force. Because I have been dealing with this matter for since long. Two aspects are there in the my lord, this kind of my lord, the discipline force. One is discipline, and
they've also mentioned the word efficiency.
Discipline, and other aspect is they
have given respect to your efficiency, sir, by promoting you. Thereafter,
promotion is an incident of service. It is not that somebody has given charity to me. It's an incident of service. I have given my service to the nation for 12 years. There is no single bad entry in my name. In all occasions, I have been marked as excellent. I am a gallantry awardee. In one hand, the Home Ministry of the Government of India is awarding the gallantry award to me.
So that is not an acknowledgement of your efficiency, sir. Your competence, your efficiency, your dedication.
Two things cannot be done because they demoralize. a force would be demoralized if he would not be given basic perquisite, basic amenities, basic respect. A senior officer, if a senior officer, kindly appreciate in a different perspective. If a senior officer in the border security force, even 6 months junior senior relationship is very strong. They pay respect to the juniors like anything. Because this is a disciplined force. Since this is a disciplined force, when a deputy commandant has to go because there is no riot, the evidence has to consider what document they have disclosed. Few words, exigency of service. Few words, there is an urgent situation. This will not do. Because those who are appearing for the Union of India or for an authority, they have certain privileges, they can use certain words, but they have to justify by producing certain documents what urgency, what necessity, or what the situation necessitated them for ordering such kind of an order when there are other officers are available. It is their duty, normally duty. Suppose there is a battle is going on, or something is untoward incident is there. That would be reported. All the document would be there. No single document has been disclosed in that regard. Only I have been singled out. They did not disclose any document that all over India, how many DCs have been appointed as an assistant commandant? The job of an assistant commandant? My righteousness cannot be taken because I am doing the work in there, I am doing the work in Malkangiri, I am doing the work in Jammu. There is no difficulty, my lord, because subsequently thereafter, I have been posted in the Naxalite areas, I performed. And I have been, my lord, subsequently when I have been given an ad hoc battalion, I have manned in a disciplined force of Bihar also. There I have got the police medal. So never I have denied to do the work in a exigent situation or in a Naxalite area or in a such area. But here the difficulty is this, only in the under the veil of certain words, under the veil of certain advantages, I cannot be face such a situation which is really embarrassment for me. I have to work with the juniors who is 12 years junior to me.
How long did you work?
Subsequently, when
How long did you work with your juniors?
So I cannot calculate right now,
But you must be knowing.
No, I did not, go for the duty when that has been ordered. And subsequently, when I interviewed by the IG ordered us. Then I went over there and did the duty because right now I am not in a position to say.
So initially, you did not join since you had to work with your juniors, right? Thereafter, you had an interview with the IG, and after your communication, discussion, whatever, you went and joined. Then how long were you there working with?
I have to see it, I cannot say any wrong statement.
Okay, next.
Kindly come to one paragraph, just one
There are
paragraph.
25 writ petitions.
My lord, one paragraph. Affidavit in opposition to their can too. He is saying that he was all along an obedient officer.
Okay,
Page 5, page 5.
see
My lord, kindly see
Indian
page 5.
state.
My lord.
May I be permitted to file my reply to the can, which has not been filed?
Which one?
The reply to the can application. Can do.
The learned advocate representing the writ petition, petitioner, has filed a affidavit in reply to the can application being 2 of 2022, filed by the respondent. It's BSF, no? BSF.
Mine.
Let the same be kept on record. Next date be fixed on 3rd of September.
We have filed our written notes for argument already.
Next.
Grateful.
I am grateful, my lord.
Out of September. Lordship, I'm praying for a Passover, Lordship. My learned senior is attending a matter in court number 12. He will soon be coming.
Ask him to come.
My lord, in this matter, Lord, I appear virtually, Lord, along with my assisting counsel who is present before your lordship in court physically. Lord, I appear for the Union of India. Now, thing is this, Lord, on the last occasion yesterday, this matter was taken up. On my ground, Lord, Passover was taken. Thereafter, it was adjourned for the day. Now, thing is this, Lord, in terms of the last order passed by Justice Rajabashu Chaudhuri, Lord, we were supposed to produce the Lord, preliminary inquiry report. Lord, since Lord, it was long back, the old records could not be traced out. Lord, accordingly, we have filed our affidavit and Lord, we have filed our written notes of argument. Lord, kindly consider the
Sir, you had placed certain truncated records. That had been the observation of the coordinate bench.
right, Lord. Thereafter,
Truncated records as produced by Mr. Datta is returned to him for him to produce the same along with the entirety of the records when the matter is taken up next.
right. Lord, the thing is this, Lord, after this order, Lord, we filed one affidavit which is taken on record, Lord, wherein we have categorically said that old records could not be traced out. Accordingly, we have filed our written notes of argument also. So, Lord, if
When
your
did you
lordship,
file that affidavit?
Lord, exact date, Lord, I cannot recollect. Lord,
Because I can't find it in any of the orders. When did you file that affidavit? Did they file any such affidavit, sir?
My lord, it was filed on 15th July 2024, my lord.
15th July.
Affidavit of compliance of the order.
Affidavit in compliance. What compliance?
Mother,
You
it
did
was
not
filed
even
on
place the records.
It was filed on 15th July, mother. Affidavit of compliance of the
Lord,
order.
in fact, Lord, we elaborated the situation why the order could not be complied with. That is the Lord, act of
That
compliance.
cannot be termed as affidavit in compliance, sir.
That's correct, Lord.
You did not produce the records.
Nomenclature should have been otherwise, Lord. Your Lordship, kindly consider why
Where is
it
it?
could not.
The file ko chita do. So you could not produce the main preliminary inquiry report.
That could not be traced out, Lord. That is, Lord,
Even entire
elaborate.
should be dropped, entire proceeding. Charge sheet was framed on the basis of preliminary inquiry report.
Do you
My
have
lord, I
a
am
copy?
coming.
Did they serve you a copy?
My lord?
Did they earlier serve you a copy of this
No.
inquiry report?
No. They refused. They said this is a confidential document. I will not supply. They refused. We repeatedly asked for preliminary inquiry report. Lots of colleague.
You have a document? Do you have their communication of refusal?
Yes.
Where is it?
Lots of colleague come to that affidavit in opposition. Lots of colleague come to their affidavit in opposition. Page 4, paragraph F first. Paragraph F, subparagraph F. Affidavit in opposition, page 4. Subparagraph F.
Dismissal. What is the date? Reply আছে, opposition কোথা দেখতে পাচ্ছি না।
Law requires, my lord, he has to show
Let
the
me complete.
prejudice
Let me
caused.
complete. My learned friends
So
should
only,
have-
only one thing, Lord, I just point out, Lord, the petitioner, Lord, need to show the prejudice cause. That is the law. Even if the
But I know
preliminary,
the law. You please stop. I know the law.
I am just submitting before my lord,
Opposition
not
is
before
not
him.
on record.
Yes, they filed the affidavit in opposition. কোথায় affidavit in opposition file করেছেন তো? হ্যাঁ, file করেছেন।
This is the affidavit in compliance of.
My lord, it
That
was
is what
filed by
is-
that. The previous advocate, my lord, it was filed by the previous advocate, my lord. It was affirmed on 23rd February 2011.
2011.
Yes.
So it's not on record. The affidavit in reply is there, but the affidavit in opposition is not there. তো আর অন্য কোনো ফাইল আছে? This is the entire, your petition is writ petition is quite bulky.
My lord,
Your writ petition comprises of
2010.
179 pages. So এটা তো restoration application. তাহলে opposition এর copy কোথায়? Are you treating this affidavit in compliance that you have served on the earlier date to be the affidavit in opposition?
Lord, the affidavit in opposition possibly has been filed long back.
এই দুটো একসাথে আছে নাকি? না?
My lord, should I hand it
can
over
both-
my copy?
Yes, give it to me.
Well, only 2 paragraphs. I am drawing your lordship attention, only 2 paragraphs. First, your lordship kindly come to page 4, paragraph, subparagraph A. Thereafter, your lordship kindly come to page 16, paragraph 29. These 2 paragraphs is very important. What is their conduct? First, your lordship kindly subparagraph A, page 4. Then your lordship kindly come to paragraph 29 of their opposition, paragraph 29.
Yes.
Can they refuse on the ground of confidential document when these sorts of charge and allegation was framed against me? Paragraph, subparagraph A. My lord, the apex court as well as the division bench of our honorable high court, on that score, the preliminary inquiry report was not supplied, entire proceeding was dismissed. I have come with the judge.
Paragraph 47 of the petition.
There they have been stated.
Well,
that
let
I
me,
have-
let me complete.
I should be
See,
served.
in my learned friend wants to argue, I should complete the matter.
So first of all, you place the affidavit in opposition or a copy of the affidavit in opposition and on record.
Affidavit in opposition. My lord, I have filed, my lord. It is,
Sir, you may have filed, but when did you file? Which date?
my lord, it was filed by the earlier advocate on record. It was affirmed on, my lord.
Yes, it was filed on 9th of January
February
2014.
2011, my lord, it was.
It was filed on 9th of January 2014.
My lord, then I shall have to file a supplementary affidavit.
What supplementary evidence?
Why will you file a supplementary affidavit? You file the copy.
You will have to file again
Again.
affidavit in opposition.
Reaffirm
it.
আচ্ছা এই ডিপার্টমেন্টকে জিজ্ঞেস করুন প্রথমে, কারণ এই রিপ্লাই আছে, এরা ফাইল করেছে, অর্ডার আছে, এখানে অপোজিশনের কপি নেই কেন? Sir, I'll adjourn it for the day so that they can find out the affidavit in copy of the affidavit in opposition. Okay, sir.
Lord, can it be
Lord,
can it be posted on next Monday, Lord, so that I can appear physically and Lord, apprise your lordship, Lord. Monday.
Anyway, there has been an admission on your part that you refuse to provide the inquiry report.
Right.
It appears from your affidavit in opposition itself.
Because Lord, no, he could not, Lord, show any prejudice which has been caused upon him.
Yes. You have the charge on the
unless specific-
corruption and no
unless
prejudice.
specific prejudice.
Yes. What does
So,
it prejudice?
Advocates representing both the parties, the learned advocate representing the respondent is to file a copy of the affidavit in opposition in case the same could not be traced out by the department prior to the next date of hearing. Next date be fixed on 1st of September.
Well, they will reaffirm the affidavit in opposition.
Sir, it is there with you. They have already filed. So it has gone missing from the record. So first let the department.
It is available on record, madam.
The order sheet says so that they have filed.
Well, opposition copy of the opposition is not available.
Copy of the opposition is not there. I have asked the department to trace it out.
My lord.
If they can't find, you just tally with it and they can give a copy. I mean,
on 1st September.
I'm extremely grateful. Extremely.
My lord, I am appearing for the CISF, my lord. This is my affidavit in opposition.
Was there any direction upon you to file affidavit in reply?
1st September.
Ashun. Reaffirmed copy of the affidavit in opposition filed on behalf of the respondent. What's BISF? BSF, CISF. Respondent CISF be kept on record. So are you filing the affidavit in reply?
We will be filing that. Not today. Grant us a date for filing the.
Affidavit in reply to the affidavit, aforesaid affidavit in opposition be filed by 15th of September. Next date be fixed on 15th of September. Next.
Sir, and for the respondent, for the lordship direction, I am filing my affidavit in opposition.
We will be filing the reply.
Although today I received this reply. Just now I received this reply.
Affidavit in opposition filed on filed by the learned advocate representing respondent number 128
Yes, Your Honor, all the responses.
be kept on record. Affidavit in reply to the aforesaid affidavit in opposition filed by the learned advocate representing the petitioner be kept on record. The pleadings are completed. Next date we fix on 19th of September for hearing.
Can it possible after this?
Twice, madam. It's of 2012. 2012 matter. Let him at least start, then you can proceed.
As you-
Next.
Thank you. My lord, I am appearing on behalf of the petition.
Lordship, I beg to appear on behalf of the respondent number 3.
Yes, madam, what is it?
My specific allegation, there, the petitioner is the.
Can you please use the mic?
My lord, petitioner is the employer of the Braithwaite Company, Lordship, and during his service tenure, he was appointed in the year 1970, I think, 79. And during his service tenure, he sought some allegations against his higher authorities, and for that he submitted several documents that he was deprived from his duties, and he was deprived from his all legible dues, etc., etc. Against that, the authority didn't adhere that allegation, against which he made a representation before the CVC, Central Vigilance Commission, and CVC did not turn up. In the meantime, in the year 2010, petitioner retired from service and he got his all retiral dues, Lordship. Now I am on that point that whether if the matter is sent to CVC and if the petitioner can be get his if that allegation is at all legible or at all admitted, or if the
There was a
petitioner get
proceeding against the petitioner.
no, my lord, no proceeding was
No
taken
proceedings.
up.
What is your prayer?
My lord,
The
kindly come to
employee had made certain allegations, Lordship, against certain activities which were carried out within the Braithwaite Company. Lordship, thereafter, Lordship, he had asked for enquiry. In our opposition, Lordship, we have disclosed all the steps which have been taken by the authority concerned pursuant to my learned friend's client's representations which were made before the authority concerned. Lordship, her main grievance in the writ petition, if my lord takes up the prayers, Lordship, it is basically for consideration of of the representations that have been filed before the Braithwaite Company. Lordship, we have already
Representations comprising what?
of certain allegations of financial misappropriation, of being ill-treated. Lordship, we have disclosed all our letters, all the letters that have been written by on behalf of Braithwaite Company.
His the petitioner's grievances were against
Certain certain activities, certain individuals who were also employees of Braithwaite Company.
barring himself.
Yes.
Then
Lordship, we have disclosed in our affidavit all the steps which have been taken pursuant to the representations that have been filed. Lordship, subject to correction and what falls from your. Lordship, all the grievances that have been addressed, because no irregularity was discovered on behalf of the company. If my lord takes up, Lordship, my opposition.
no, he's saying claim of the dues of the petitioner.
All dues have been cleared. There are no dues.
At present, there are no dues. If
If
the petitioner during his service tenure, he did not get the promotion as per his his service tenure, as per his seniority. So, if petitioner is allowed to get the actual promotion, then some notional benefit can be given to the petitioner
Without any proceedings, without any other
Lordship,
how can you prevent him?
Lordship kindly takes up paragraph 3 of the writ petition once.
Paragraph 3.
May I just place for my that the petitioner states that at the time of his service, when he was on duty in the said post, he complained several misappropriation by respondents and also not giving promotion in time and not releasing his claim in proper time. Paragraph 4, your petitioner states that during his service period and after retirement, he made several
So
complaints.
this petition was filed after his retirement.
Yes.
Hmm.
Your petitioner states that during his service period and after retirement, he has made several complaint representation to the authority concerned, but till date, no steps have been taken and not release the dues of the petitioner with proper estimate and deliberately crime-like injustice. Lordship, these were the allegations. Kindly comes to the next paragraph that your petitioner states that the respondent authorities are not taking proper action and injustice upon your petitioner for not giving promotion and not releasing his
After
claim.
retirement, you want promotion.
No.
Then?
After retirement, I got my retirement dues. I am praying.
No, but then you are saying that your petitioner,
During the service tenure, due to that atrocities of that individuals, he was not promoted as per his actual seniority.
Lordship may now kindly turn over to page 15. This is annexure P1 of the writ petition. Lordship, here the writ petitioner has enumerated his grievances against the company. Lordship may now kindly take up my affidavit in opposition.
Yes.
Kindly turns over to page 3, paragraph 5. Lordship is on paragraph 5. Lordship, the 6th line from the top, with reference to the allegations made by the petitioner in course of the letter appearing as P1, I say that, Lordship, here we have all, Lordship, all the grievances that I pointed out that he has raised.
I see that the advances in personal names were a prevailing practice of the answering respondent at a point of time.
Yes, Lordship, however, said practice has since been stopped. The same being an internal policy of the answering respondent does not affect the rights of the petitioner in any manner whatsoever. And as such, the allegation after a prolonged time is merely speculative in nature and so for the sole purpose of harassing the answering respondent. I further say that the petitioner was a habitual latecomer and had been warned on several occasions during his service tenure. In this regard, the answering respondent had issued a representation on June 19, 2004 through its deputy manager to the petitioner requesting him to attend his duties on time, to which, failing which, the petitioner shall be liable to face disciplinary action as per rules of the answering committee. Lordship, this letter, it is annexed. It is there, annexure R1. Lordship kindly comes to the second allegation. The allegations of bad comments made by one such and such in note sheet dated 2004 and show cause letter dated April 27, 2005 are equally false and frivolous and are mere afterthoughts. And the petitioner has come up with such allegations after a period of almost 9 years since the occurrence of such incidents. However, the answering respondent states that the petitioner was neither authorized nor entrusted to look after the files, but despite the same, he handled the files in a very casual and irresponsible manner without care. Lordship will kindly take up annexure R2. Well, this is addressed to the petitioner. This is with regard to procurement of cables.
Okay, then.
Lordship, some certain files. This is not the subject matter of dispute in the writ petition. Lordship, this is also annexure R2 is annexed. Lordship, this show cause letter. Then Lordship kindly turns to where it is in bold, Lordship, annexure R2 towards the middle of the page, page 4.
Taxi fare is also there. Allegation of non-payment of taxi fare.
Lordship, that is addressed at page 7. With regard to the allegation of non-payment of taxi fare, I said that the allegation is fanciful and whimsical and does not merit.
Okay,
With
sir. Okay, madam, I'll fix it for orders.
Yes.
Lord, my simple submission is all the grievances that are there, Lordship, has been
Got
adequately
discussion of
addressed.
learned advocates representing both the parties. Next date we fixed on 19th of September for orders.
I'm grateful.
Next.
I am for the respondent. I am for the petitioner, my lord. So this matter was heard by your lordship, my lord. We have filed our notes of argument. We have challenged, my lord, the termination order on, my lord, 3 grounds, basically, my lord. First is that natural justice violated because when the disciplinary authority disagreed, as per rules, they have to give a fresh hearing, not given. Order, inquiry, disciplinary authority as well as appellate authority, my lord, absolutely cryptic order, just not quoting the submission and one line order that charge is proved and punished. So there is no reason, nothing, no non-application of mine. And third point was disproportionate. That although he pointed out to the authorities that I have taken this money, although he admitted, but he pointed out that he has taken the money, returning no loss to the bank. In spite of that, my lord, the bank was not aware also. In spite of that, they have terminated, my lord, without any retirement benefits, my lord, which in our humble submission, considering his conduct, was disproportionate. These are the 3 points your lordship heard and lord notes were
This
taken.
is that
State Bank
employee.
my lord. Both of us, do you advance the arguments, my lord?
Okay. The one he was the one who had taken that money on account of the mother's
Mother was
illness.
from cancer. He had taken the money, but paid the entire interest and money back and pointed out that I have done this.
And he customer deposits the money and he received
No loss
used
to
that
the
money.
Bank's own
used
report, no loss. Entire money has been returned, but
he used the money for his own purpose.
first
According to him, unless and until he had pointed it out, nobody really could
No, before that,
point
it could be,
that
before that,
amount had
conduct,
been
that is one submission.
before that, it could be ascertained by the by Belapur, our containing office. They indicated that the amount was credited in the account.
On my application, I
amount was deposited, but no
second
amount
point
is
is that
credited.
all the orders are cryptic without application of mind. If the order is set aside today on that ground, my lord, he has already attained the age of superannuation. They cannot continue any further.
There is misappropriation of fund is there, my lord. And banks.
Next.
এটা চলে যাও, তোমার একটা দিকে লাগবে।
I am for the petitioner.
35 minutes, I am appearing for the respondent number 1, Union of India.
Lordship, I am appearing for respondent number 2, 3, and 4, answering respondent, Indian Museum. Lordship, we are on the restoration application today. The petitioner, the petitioner employee of Indian Museum, charges of gang rape, complaint filed by Japanese tourist lady.
Today.
You are told.
Yes, I am supposed to file the report of the disciplinary proceeding before your lordship.
May I be favored with a copy? Subject to your lordship.
Now the
charges are many.
Your lordship may come.
Frivolous charges are
The
many.
narration of the disciplinary proceeding, each and every step has been narrated at page 2, paragraph 3, my lord. And the presenting of it,
under suspension, right?
petitioner is under suspension.
You had been asked to file a report.
Report, my lord.
Now tell me what has happened. What have you
Lordship-
stated in the
My
report?
lord,
Lordship,
may I be given a copy, my lord? I'm extremely sorry, my. I tender my humble apology.
Yes, what have you mentioned in the report?
Lordship may kindly come to para 3, page 2 of the report, my lord. The entire narration is there. The authorities of Indian Museum, Kolkata were informed that an FIR being Park Street Police Station case number such and such under section.
It's okay, but what is the status? That is what
Lordship-
you had to.
Lordship, the presenting officer has already submitted his report to the inquiring officer, and only report of the inquiry officer is pending. The inquiry officer submits the report and we take the.
There was a stay granted by this court on only.
No stay is there. No stay is there. We are just on the verge of completion of the disciplinary proceeding. The inquiry officer submits the report and we take the step. My lord, may only come to one thing, my lord. My lord, may kindly comes to page 90, page 90, my lord.
90 of?
90 of this report, page 89. We have already intimated the inquiring officer to submit the report at page 89, annexure R14. We have requested him to expedite the submission of report. In connection to that, in the next page, your lordship will find he sought for certain factual clarification at page 90. And in the next page, your lordship will find at page 91, we have given him all the clarifications, and your lordship's last order at page 93. It has been communicated to the inquiring officer that your lordship has asked for the status report of the disciplinary proceeding at page 93. And my lord, kindly.
So don't you think that this process should have been completed by now?
Yes, my lord. My lord kindly passes an order upon the inquiring officer, because we have repeatedly reminded him he is not under our control and the entire process cannot be start afresh. My lord, that your lordship's order will suffice, my lord.
To the result of the appeal that you had filed?
Appeal, my lord.
One criminal revisional application is pending. It has been disposed of.
I could take instructions. I am not briefed in that. I could.
My lord is looking at page, my lord, kindly.
78, paragraph 2.
We also don't have any idea regarding the criminal revision. What he did, he preferred a writ petition challenging the suspension that was dismissed for default. He preferred a restoration application that is today before your lordship. Suppressing that, he preferred another writ petition on the self-same cause of action that was adjudicated by her lordship Lapita Banerjee. That gross suppression is there, and her lordship was pleased to dismiss the matter. And my lord, thereafter filed another restoration application which has been not placed before your lordship. Now the previous restoration application. This is the messy affair of the proceeding. And my lord, the petitioner, I must submit before lordship, have very scant respect for the honorable court, because repeatedly he has tried to mislead this honorable court. In his pleading, in the second restoration application, which has not been praised, he specifically submitted that he didn't have any knowledge regarding the institution of this restoration application. His lawyer didn't appear. He could not have arranged fund. Now the date of the affirmation will clearly make before your lordship evident that he has very specific knowledge of filing of this restoration application.
What is their prayer here?
My lord,
What is the prayer here? In the
they have challenged the suspension, my lord.
Challenge the suspension.
My lord, the disciplinary proceeding. Lordship will come to the prayer of the writ petition at page
10 of the writ petition.
10 of the writ petition. A writ of or in the nature of mandamus directing the respondent authority to cancel, rescind, withdraw the suspension order. Being memo such and such dated 8th January 2015 and memo such and such issued by the director whereby suspended the petitioner and further be pleased to direct the respondent authority to allow the petitioner to reinstate in service. A writ of or in the nature of.
Did the petitioner file the criminal revision application for quashing? For what? You don't know? CRR 2734 of 2023? Earlier, He was the driver of any vehicle.
But what the allegation is that no, the allegation is that I was driving a vehicle. I took a woman from Kolkata to Mandarmoni, and there was a rape.
Why were you posted as driver in the?
I was not posted as a driver. These are mere allegations. In
He's-
PI parrot, I could not be identified by the complainant.
He was doing perennial jobs in the Indian Museum.
I
He
was
approached
not
that lady, that victim lady,
Numerous charges
to
have been framed.
facilitate him to show Bodh Gaya. Rather, he and his associates took her to Mandarmuni, gang raped, extorted, then taken to.
I'll fix it for orders.
Lordship.
Ashwin.
Order of the writ petition, my lord.
Entire
Writ
petition.
Number one, Union of India is also adopting the minute same.
The report in the form of an affidavit filed by the learned advocate representing respondent number 2, 3, and 4 in compliance with the order dated 9/7/2025 passed by this court be kept on record. Next date be fixed on 22nd of September for orders. Next.
Grateful, my lord.
47.
Yeah.
Milord, on 12th March 2025, Milord, there is a direction upon me to produce records, Milord, on behalf of High Court Administration. Milord, the records which I produced, Milord, were not sufficient. Today, Milord, I have, Milord, some more documents from the end of High Court Administration. May I, Milord, hand it up once?
Who is appearing for the petitioner?
Milord, these are, Milord, official records. Kindly take, Milord, immediately after my letter, Milord, there is a bunch which has, Milord, freshly come. The dispute is with regard to, Milord, the petitioner's alleged entitlement to super time scale of pay. Milord, allegation was that, Milord, one gentleman, Milord, one judicial officer who was, Milord, junior to him, Milord, had got, Milord, super time scale of pay, Milord, over, Milord, surpassing him. That was, Milord, the allegation. Now, Milord, these documents which my lord is now looking at shows that, Milord, there is an erratum, there is an error, Milord, indicating the date with effect from which, Milord, the junior judicial officer was supposed to get, Milord, the super time scale of pay, which was later on rectified. So when it is allegation, Milord, that forms the foundation of the writ petition, really has no basis. If my lord wants me, Milord, to disclose this, Milord, through an affidavit, Milord, we can do that.
Let this be kept on record. You file an affidavit, you serve them a copy. So it will be conspicuous to them also.
Very well. Milord, may I make a photocopy and hand it over to my lord's court officer? I have, Milord, no copy with me otherwise.
So by 2 p.m. you do that? So you can.
They will file it. Milord, my learned junior would come and, Milord, make it over to my lord's court officer.
Yes. The learned advocate representing the respondent number 2 and 3 submitted to have obtained the documents to be filed
এটা করে এখনই দিয়ে
for the
যাবে
court.
এখনই আইটেম নাম্বার
He
বলে
is to file the same prior to 2 p.m.
Yes.
The learned advocate representing respondent number 2 and 3 further seeks permission of this court to file an affidavit,
বা সাপ্লিমেন্টারি এফিডেভিট ডিসক্লোজিং মিলট
supplementary affidavit pertaining to the relevant documents disclosing the status of the petitioner with regard to his claim in the writ petition. A copy of the same is to be served upon the learned advocate representing the petitioner. Next date we fixed on 11th of November.
গ্রেটফুল গ্রেটফুল এখনই দিয়ে যাবে এখনই
Next.
48.
Your Lordship, I appear for the Union of India.
About the petitioner, my lords. I appear on behalf of the petitioner. My lord, this is the evidence in reply to the opposition, my lords. My lord,
It was served yesterday, Your Lordship. I was humbly praying that the matter could be taken up after 2 weeks. My senior is unwell in this matter.
Affidavit in reply filed by the learned advocate representing the petitioner is be kept on record. The pleadings are completed. Next date be fixed on 13th of November for hearing.
but you know, my lord, a very short matter. It will not take 5 minutes. Either matter may be dismissed because of the recruitment in 2014 in the post of constable. So now the petitioner agent, if your lordship pass such an order in favor of the petitioner, then my lord, is there only 2 months is left, my lord, for getting the service regarding his age. And if your lordship dismiss the matter, only I will take 5 minutes. They have already filed their reason order. Keep your lordship fixed at any short date, my lord.
Is it you are challenging the process of recruitment?
No. I came for measurement. I have participated in the selection process. I have completed all the examination. Only measurement they have rejected my claim. I came before this honorable court for re-measurement. Re-measurement which has been done in a hottest manner without taking my measurement. I have been rejected. I have been thrown out from the selection process. Only this is my point. Only my lord, if
Your Lordship, this is 2016 matter.
Grateful to lords.
23rd September.
23rd. Grateful.
Much obliged.
Next.
But I'm appealing for the petition.
Number 40, pursuant to my lord's order,
Yes, so that
that I have to file a report on behalf of CSTC today. Now, my lord, yesterday, my lord, I was told that, my lord, to pray for 1 week time, my lord, with regard to that filing of report.
why, sir?
But just now, my lord, I am told that yesterday I sought for a report. They said that so that I can.
Who has asked you to do that, sir?
My lord, the law superintendent said that it can be ready within a 2 or 3 days, but it would be, my lord, the benefited if 7 days time is given.
But sir, you had
I
to
know
file
that-
the report
that
because they have already
Yes.
obtained that,
Yes.
their
In
refusal.
reply to those 2 letters of CSTC, they have already
Yes, on
kept
the other
reply.
earlier occasion,
And
your
on that,
junior was there.
only report to be filed, that yes, what is there, stand on the basis
They
of the
have said
report.
they had refused.
And they have, yes, grateful to your lordship.
That is what your
And that's, I have to submit that they have regretted that they have
Yes.
refused. So kindly give, I have no other option but to pray before your lordship that the report is not ready.
So last chance.
Last chance, my lord, last chance.
The learned advocate representing the CSTC seeks a week's time to file the report in compliance with the order dated 12/8/2025 passed by this court. Next, let the matter be fixed on 26th of August as last chance. You had
Lord,
just
except Lord 26, Lord, any date, Lord, I have Lord
27th.
date, Lord. Date.
Next. Ajaligan, none appeared to represent either of the parties. Let the matter be dismissed for default. Next.
I am for the respondent, Lord. Although I am for the respondent. Oh, sorry. Last time, Lordship directed to file reply.
None appeared to represent the petitioner. The learned advocate representing the respondent, number 226 ECL, is present. Let the matter be adjourned for the day as last chance.
Date, Lord.
They had to file the affidavit and reply today. Next.
Lordship, appear on behalf of the petitioner in this matter, Your Lordship. I am praying for an accommodation today, Your Lordship. Your Lordship, the learned arguing counsel is keeping unwell, due to which he is not attending court currently, Your Lordship.
So you had to start today.
My Lord.
Yes. Start.
Your
My Lord.
Lordship, may
You
kindly
take note. Yes.
My Lord, the issue, what I understand from the writ petition is that whether the order of order of warning equates with censure, and if yes, then whether the procedure required in awarding or passing the order of censure has been followed or not, because promotion will be a consequence of the first. My Lord, first kindly take note of first I will rely upon a judgment wherein what is censure and what is this warning has been distinguished. Judgment. Madam কে একটু কপিটা বলে দে আমার কপি সাইটেশনটা দিয়ে দে ব্রিফটা দিয়ে এখন দিয়ে দে আপাতত My Lord, first kindly take note of paragraph 1. In this case also, it is with regards to the facts. In this case also, there was an order of recordable warning which was passed against the petitioner. My Lord, now kindly come next to paragraph 6. What was the issues to be decided? Two questions arise, my Lord, may I read? Two questions arise for decision. Firstly, whether a recordable warning could have been issued to the petitioner without affording him an opportunity of showing cause against, and secondly, whether the order of transfer such and such. My Lord, thereafter kindly take note of paragraph 9 onwards. Here it deals with everything.
But prior to that, paragraph 6,
Paragraph 6, my Lord,
they have defined minor penalties.
minor penalty. In this case also, my Lord, recordable warning does not fall within the meaning of minor penalties. It has not been included at that relevant point of time. And it has been, my Lord, it has been entirely quoted in the paragraph of the writ petition. Minor penalty, what is minor penalty and what is major penalty. My Lord, now kindly take note of, I will read from 9 onwards, my Lord. Paragraph 9. It is to be seen
whether the recordable warning issued to the petitioner amounts to imposing a minor penalty of censure. Paragraph 10. The word censure is not defined in the regulations or elsewhere. In the case of my lord Coal India also, the discipline and appeal rules, the word censure has not been defined anywhere. My lord, may I just hand over a copy of it for my lord's record? If required, I will rely upon the same. এটা একটু পরে বলে দিচ্ছি। এটা থাক রেকর্ডে থাক ইম্পর্টেন্ট। The word censure is not defined in the regulations or elsewhere. We may with advantage extract and reproduce the Government of India Ministry of Home Affairs OM dated such and such. An order of censure is a formal and public act intended to convey that the person concerned has been guilty of some blameworthy act or commission for which it has been found necessary to award him a formal punishment. And nothing can amount to a censure unless it is intended to be such a formal punishment and imposed for good and sufficient reasons after following the prescribed procedure. A record of the punishment so imposed is kept on the officier's confidential roll, and the fact that he has been censured will have its bearing on the assessment of his merit or suitability for promotion of higher post. There may be occasions, on the other hand, where when a superior officer may find it necessary to criticize adversely the work of an officer working under him, that is, point of negligence, carelessness, lack of thoroughness, delay, etc. Or he may call for an explanation for some act of or omission, and taking all circumstances into consideration, it may be felt that while the matter is not serious enough to justify the imposition of the formal punishment of censure, it calls for some informal action, such as the communication of a written warning, admonition, or reprimand. If the circumstances justify, a mention may also be of such a warning, etc., in the officer's confidential roll. However, the mere fact that it is so mentioned in the character role does not convert the warning, etc., into censure. Although such comments, remark, warnings, etc., also would have the effect of making it apparent or known to the person concerned that he has done something blameworthy, and to extent may also affect the assessment of his merit and suitability for promotion, they do not amount to the imposition of the penalty of censure, because it was not intended that any formal punishment should be inflicted. The fact that a mere informal warning cannot be equated to a formal censure should not, however, be taken as tantamount to suggesting that a written warning may be freely given without caring whether or not it is really justified. It is a matter of simple natural justice that written warnings, reprimands, etc., should not be administered or placed on an officer's confidential records unless the authority doing so is satisfied that there is good and sufficient reason to do so. Paragraph 6 of the Home Ministry's Office Memorandum dated 27 January 1955 provides detailed guidance in the matter of recording adverse remarks in confidential reports. It may be reiterated here that in the discharge of the responsible task of recording the confidential reports, every reporting officer should be conscious of the fact that it is his duty not only to make an objective assessment of his subordinates' work and qualities, but also to see that he gives to his subordinate at all times the advice, guidance, and assistance to correct their faults and deficiencies. If this part of the reporting officer's duty has been properly performed, there should be no difficulty about recording adverse entries, because they would only refer to the defects which have persisted in spite of reporting officers' efforts to have them corrected. If after having taken such care, the reporting officer finds that for the purpose of truly objective assessment, mention should be made of any warning, admonition, etc., issued, especially those which have not produced the desired improvement, it is his right and duty to so mention them. In the process of bringing the defects to the notice of person concerned, where an explanation is possible, an opportunity to do so should be given. These cannot, however, be equated to the formal proceedings required to be taken under rules such and such of CCS, classification, control, and appeal rules, nor the warning gives amount to the imposition of formal penalty. My lord, paragraph 11. In Chambers' 20th century dictionary, the word censure is defined to mean an opinion or judgment, formerly general, now unfavorable only. Blame, reproof, to form, give an opinion or judgment, now unfavorable of. To blame, to condemn as wrong, to sentence. According to the same dictionary, warn means to give notice of danger or evil, to notify in advance, to caution with, against, to instruct, command, to demolish, to forbid. Warning means a caution against danger, etc., something that gives this previous notice. In the new lexicon Webster's dictionary, deluxe such and such, censure means adverse criticism, blame. Warn means to draw the attention of someone to the probable result of an act or to impending danger. To inform beforehand, to rebuke someone mildly for misbehavior, breaking a rule, etc. My lord, kindly note this word also. To rebuke mildly for a misbehavior, breaking of a rule, etc. Wharton's law lexicon defines censure as a judgment which condemns some book, person, or action, more particularly a reprimand from a superior. Censure, paragraph 14. Censure or warning may appear to be something similar in as much as the object behind both is to reprimand an erring employee. However, the two have distinct connotation and perception in service jurisprudence. The penalty of censure punishes an employee for something done in the past and found proved in a process in which an employee has a right to participate. Warning does not punish an employee. It puts an employee on its guard for future and is issued on facts enabling formation satisfactorily of a bona fide opinion, though such facts may be found in a process in which the employee did not have the opportunity, much less a right of participation. Penalty is for the past. Warning is for the future. Penalty proceeds on a decision. Warning wishes. Let there be no occasion for a decision. Paragraph 15. Thus, warning is not necessarily a penalty of censure. Warning may be oral or in writing. If it is oral, it remains matter between the officer issuing the warning and the employee receiving it. All its efficacy is lost no sooner one of them is transferred or shifted so as to snap the proximity of relationship between the two. If the warning is writing, my lord, this is very important, para 16. If the warning is in writing or a recordable warning, it is in its legal implication akin to an adverse entry in the confidential records of the employee. Though the employee was not intended to be penalized, yet being a recordable warning, it goes in the personal record of the employee and becomes relevant for the purpose of assessing the overall performance of the employee. A recordable warning shall therefore have to be dealt with online similar to ACRs. Though no opportunity of hearing or notice to show cause against need precede the issuance of a warning, yet the employee must have an opportunity of making a representation against such a representation, if made, shall have to be considered and disposed of by the authority issuing the warning or its superior authority. This alone will be consistent with the principles of natural justice and fair play. My lord, I am not troubling with with paragraph 16 where the differentiation which has been recorded in the earlier paragraphs has been stated. Now, my lord, going back to the case of the writ petitioner. My lord, the writ petitioner has impugned two orders. First is an order dated 12/22/10/2013, wherein the order of recordable warning has been passed. And second is the order of the appellate authority passed in the year 2017, wherein no interference has been recorded. Now, my lord, the ground of challenge, what I could gather, is that no opportunity of hearing was granted to him before issuance of the order of recordable warning. My lord, kindly take note of, first, what was asked from the petitioner. My lord, kindly first take note of annex page 37.
Yes.
My lord, it was, if I only point out to the subject which has been mentioned herein, my lord, it will be ample clear that only a clarification or comment was sought for from the petitioner. What was the was the background of seeking this clarification or comments from the petitioner is that my lord will find that at paragraph 2. Since, my lord, may I read?
Which page did you say?
My lord, page 37 of the read petition.
There's a, oh,
My lord,
it's a chart.
no, my lord, where page 37 of the read petition,
Annex to P1, your lordship.
P1, একটু দেখাবেন একবার অর্ডারটাও দিয়েছি যেটা দেখালাম
Yes.
my lord. My lord, it was issued by the general manager. It is the, my lord, foundation of the order of recordable warning. My lord, what was the sought from the petitioner? My lord, if you take note of the subject, it is a clarification and comment in respect of procurement
Yes.
of square steel. My lord, what was the background? My lord, we'll find that at paragraph 2. Since you are technically evaluated the offers and hence you are requested to submit your version, comments on the lapses, irregularities pointed out by this department as mentioned in Annexure A within 10 days. So, my lord, simpliciter, a comment was sought from him.
Yes.
Now, what was the response? My lord, will find the response at page. I'm not troubling, my lord, with the response. It starts from page 40 and ends at page 43. I'm not troubling, my lord, with the response. So, my lord, in this regard, my first, as has been pointed out, paragraph 16.
So he answered the queries.
He answered the queries. Now, my lord, kindly come to the first order which has been impugned, page 44. My lord, it is one dated 22nd October 2013.
Yes.
My lord, may I just read once the order? Whether it is a, whereas during an investigation by Vigilance Department,
Then
recordable warning was awarded to him. Now, my lord, it is an admitted fact that even in CDA rules of Coal India, even if there is a imposition of minor penalty, opportunity of hearing is not required. Where, my lord, from which basis I am making this submission? My lord, I have just handed over a copy of that rules. My lord, kindly take note of page 39, page 40 of the CDA rules. My lord, the page number is at the bottom.
Yes.
My lord, minor penalties has been defined at clause 27. I'm not troubling, my lord, with the minor penalties. My lord, 31. What will be the procedure? Where it is proposed to impose any of the minor penalties specified in Rule 27.
You're reading from this?
Yes, my lord, the one that I handed over today.
This one?
Yes. My lord, page 40, the pagination is at the bottom. My lord, 31, I will be reading clause 31.
Procedure for imposing minor
Yes, madam. Yes, ma'am. My lord, where it is proposed to impose any of the minor penalties specified in Rule 27, the employees concerned shall be informed in writing of the imputations of misconduct or misbehavior against him, her, and given an opportunity to submit his written statement of defense within the specified period not exceeding 15 days. Therefore, my lord, even in the case of imposition of minor penalty, there is no occasion to give an opportunity of hearing to the petition to the one who has been issued a charge, to whom the proceedings of minor penalty has been undertaken. Therefore, the contention of the petitioner that an opportunity of hearing was denied to him is irrelevant given the rules as well as given the judgment that I have just cited. which clears the entire aspect of what is warning and what is censure.
Right, but
My lord.
you come to paragraph 16 that you had mentioned.
My lord.
In the judgment itself.
Yes, ma'am.
Right.
Yes, ma'am.
Though no opportunity of hearing or a notice to show cause against need precede the issuance of a warning, yet the employee must have an opportunity of making a representation against, and such a representation, if made, shall have to be considered and disposed of by the authority issuing the warning or its superior authority. This alone will be consistent with the principles of natural justice and fair play.
My lord.
Now, did they prefer any representation before you?
My lord, page that comments or page 38.
You sought for certain
comments and version on the background that certain the technical that the gentleman evaluated or tender.
You had asked the petitioner
Yes, ma'am.
to provide explanation to your queries.
My lord.
That was done.
Yes, ma'am.
But the petitioner was not in a position at that point of time to assess as to your future action.
My lord.
Right? Whether you will be imposing the minor penalty of recordable warning or censure or any other major penalties
My
for
lord.
that matter. The petitioner was not aware.
No.
So now once you had imposed that penalty, you could have issued a show cause.
Then, my lord, subject
You
to
could have,
my lord.
but you are bound by the conduct, discipline, and appeal rules of 1978,
My lord.
where you have just shown me 31.
That part, first there has to be a demand and thereafter representation against him, then the order.
Then the order. So, don't you think that gap is still there?
My lord, subject to kind approval from my lord. My lord, my understanding is that since censure is not a warning is not a type of censure, therefore the procedure which has been mentioned in 31 is not required to be followed, because the word recordable warning has not been defined anywhere.
Right.
My lord,
but you are again relying on this judgment, sir.
to show why
Not only to show the distinction, but also the implication. Right? So, paragraph 16 is writ large.
My lord, taking no cue from paragraph 16, my lord, my interpretation of page 37 will be that this was the opportunity which was granted to him by making him known of the fact that the bid which you have evaluated, after your evaluation there was certain irregularities.
You did not mention as to whether.
Yes, ma'am.
As to whether you were satisfied with the reply or not.
My lord, that my lord will find at page the 44. After receiving his reply,
you directly impose recordable warning.
Yes, my lord, because in the case of recordable.
So prior to that,
my lord,
you did not ask him as to why this warning should not be imposed upon you.
My lord, it was not subject to my lord's kind approval. My lord, it was not required as well.
Say that the queries issued by you seeking explanation itself was a show cause.
Was a show cause. Can be construed within the meaning of show cause. My lord, now may I just draw my lord's attention to page 44 once. Why this submission has been made on my part? Because, my lord, in the case of this can be construed to be a preliminary hearing or preliminary opportunity granted to the petitioner, whether at all any imposition of any proceeding disciplinary action is required or not. My lord, may I just read once, my lord? Whereas during an investigation by the Vigilance Department in respect of the procurement of such and such.
This is something which you have stated earlier also.
And whereas, my lord, paragraph 2, whereas after receiving his response from our comments, the reasoning part starts, my lord. Whereas Sri J.P. Gupta, that is the
You
petitioner.
have come to paragraph, this also appears in your earlier queries. You come to paragraph 3.
My lord, may I read?
Yes.
Whereas the undersigned, where being the disciplinary authority, after carefully going through the above facts, circumstances, and relevant documents, along with reply of Sri J.P. Gupta, is of the considered opinion that by taking a lenient view and by imposing recordable warning on Sri J.P. Gupta for the unjust gestures would be made. My lord, I can gather what is falling from my lord, that you yourself has stated this to be a disciplinary, you are described yourself to be a disciplinary authority. Then whether the requirement of paragraph or clause 31 was a necessity or not.
Along with the opinion of the Honorable Judge in the decision that you have cited in paragraph 16.
Yes, my lord. I am also stuck in this point. I am just that once you are saying that you are the disciplinary authority, then ought to have been done some manners.
Ashun, so I'll fix it for orders.
Yes, I will just conclude my next day.
My lordships, I appear for the petition, my lordships. I'm extremely sorry I could not be there physically, my lords, and I have had to come to the court. My lordships, the only thing is, my lords will recall on the last occasion, my lordships, I had made extensive submissions with respect to the aspect of PRP, my lords.
But the submission of learned advocate representing the respondent, you are for?
My lord, Coal India.
Coal India.
Respondent 1.
No.
All the respondents. All the
respondents.
No, so the report has been filed with BCCL.
My lord, the aspect of performance related pay, my
3rd
lord.
of September.
My lord. My lord. 23rd, I am submitting. Can it be on 24th?
24th of September.
My lord, I'm only praying, my lord, this much, that if they can be directed to bring the relevant records regarding performance related pay, my lord, of the petitioner, my lord.
Next.
I'm grateful, my lord. Huh.
The 51 hearing was concluded. Madam, the direction was given to submit a written notes. Well, I failed, my lord. I was seeking.
You always fail, sir.
Well, I was seeking some
I was
time.
wondering as to why you.
Well,
on the last occasion also, sir, you did not appear. And you have your friends on the other side. You tell them that today I'm not going. You also better don't go.
I always inform other side if I do not do that matter. But here, madam, the hearing was concluded only.
Sir,
only two pages submission.
It seems that you are not interested to file the written notes. So let us fix it for.
No, hearing has been concluded. Hearing has been concluded. Written notes, if your lordship permit, coming week I can submit. 2 pages will be sufficient.
So you.
No, I
think I will recall the. The learned advocate representing the petitioner is present. None appears to represent the respondent state. Let the matter be reserved for judgment. As you are saying, in the meantime, if you are ready,
then I will get.
Again, it depends upon your time. Your
Extremely grateful, my lord. Your lordship.
You can file it within 10-15 days.
Very extremely grateful.
I am the petitioner, my lord.
And for
Things are connected matter, my lord. Both have been.
In this matter also, so you are there.
My lord, I filed a writ petition. They filed a writ petition. And challenging the decision, I also filed a writ petition. The both were directed to be heard together. And one matter has been assigned to your lordship.
The first matter is not
I have also
my matter.
They filed the report both. I have also used an exception as subject. Let it be taken on.
Report filed by you, madam?
Lordship. That is in the second matter. First matter also, the report filed by your lordship, sir.
The first matter, my lord, which is a much prior matter of 2017, the grievance was that, my lord, the gradation list was not done according to initial entry as per merit. Because the rules say that the seniority has to be assessed and fixed as per merit position in the entrance examination. That was the grievance. Now, my lord, they were not initially disclosing, my lord, they were not having the copy of the original entrance test to ascertain the merit position. That was their stand. After a long battle, my lord, ultimately they retrieved, my lord, some documents to ascertain the status in the, my lord, initial examination, from on the basis of which, my lord, we said that our position should be in a much higher place in the gradation list. This honorable court directed a fact-finding inquiry was going on the gradation list. This court directed us, you also approach the committee and raise your grievance. We raised our grievance before the authority. The authority, after consulting all the documents, my lord, said that we have a case. Our position should be recast on the basis of merit. Now that recasting has been challenged in the second writ petition by my learned senior friend. This is the position.
How are you aggrieved, sir?
Because of the fact, madam, the gradation list which has been prepared, my lord, they have wrongly prepared, because if that gradation list taken into consideration, the current gradation list, then my lord, I will be in the lower positions. There was, two categories, and 1996 appointment, and thereafter there 2000. So my lord, here there was a committee. My learned friend's client came before this court, praying for direction upon the board. The board, my lord, made a submission that they will consider the prayer. They constituted a fact-finding committee, and fact-finding committee passed an order. Initially, they said, I have given the document in my exceptions, that there is no such policy. It was adopted. Now the first time, I, my lord, challenge the same. The inquiry committee, which
I think it will take some time. I'll fix it at 2 p.m. one day. Okay. You file the
let
exception.
the report be kept on record. যে কোনো দিন একটু fix করে নিয়েছেন 2 p.m.
Well, the thing is that, my lord, in 1996, the petitioners were appointed. My lord, as clerk,
You have filed the exception to
my report.
Okay.
In the second writ petition. I am for the West Bengal Board of Secondary Education.
The respondent number?
My lord, I am respondent number.
Ashun. Exception.
My lord, 4.
The learned advocate representing the petitioner in, sir, you are in 21988.
21988.
Madam, you had filed the report in 21988 of 2024.
Yes.
Lordship.
I have used an exception to
The
that.
learned advocate representing the petitioner in WPA 21988 of 2024 has filed an exception to the report filed on behalf of the West Bengal Board of Secondary Education, that the same be kept on record. So you are not concerned.
No,
I am concerned
So
because
did you receive the copy?
yes, I have received the copy, my lord.
Okay.
Exception page.
Because but if their contention is accepted, then my position again goes down.
Well,
Both the matters will be heard.
thing is that in the first time,
Ultimately, now I remember that after the intervention of this court, you could have at least prepared
we
the
have prepared, yes, after
gradation
lordship
list.
intervention, we have
Which they
prepared.
are challenging. My
That
submission is my lord,
they are challenging. My lord, just may I give a little background, my lord. Board does not have any own rules and regulation, it is service rules. So, my lord, which rules is to be adopted? First, my lord, in 2017, my lord, a gradation list was prepared by the board, where for the appointment of 1996. Where persons who were appointed in 1996, thereafter first gradation list were prepared in 2017, where it was taken the date of appointment as seniority was the basis. So, my lord, that was challenged. Because, my lord, next appointment took place in 2000. And my lord, in 2017, another gradation list was prepared. There is on the basis of merit cum seniority. So, 2 type of gradation list prepared. So, my lord, that was under challenge by this petitioner number 1. So, my lord, thereafter, my lord, the court directed to publish a gradation list. My lord, thereafter, another coordinate bench before the matter came before the lordship, under direction of that coordinate bench, my lord, board has constituted a 3-month commission, not committee, a 3-month commission. All persons from the service of the state government who have not prepared the gradation list, who have recommended a board, which in absence of any own
Okay, you
rules,
come
which
back
is to be
on
adopted.
10th of September at 2 p.m.
Lordship,
Let the matter be fixed on 10th of September at 2 p.m.
My lord, may I? I'm very sorry, my lord. Item 51, my lord, I was in my lord, the other court. But my lord, in item 51, my lord, so far the state is concerned, my lord, the report in the form of affidavit file, they, my lord, so far I am concerned on behalf of
I
state.
don't have the record.
My lord, I am told that, my lord, since none appears for the neither writ petitioner nor the respondent, my lord says that let it be CAB hearing concluded. Petitioner ছিল? ও তুমি ছিলে? বলে কেউ ছিল না? না, my lord, on last occasion, my learned friend said that he would withdraw the case. বলেছিলেন না?
সিএপি হয়ে গেছে, আমি বলেছি যে রিটেন নোট দিতে পারিনি।
আচ্ছা।
জজ সাহেব 2 সপ্তাহ আমাকে বলেছে পারো তো এটা দিয়ে দাও।
I shall also file written note because my submission already, my lord, concluded. Then, my lord, Lordship, kindly, my lord, give me
You
some
also file within 2 weeks, sir.
3 weeks, Lordship. Kindly give me, my lord. There
Okay,
are
3 weeks.
so many, my lord. Lordship, kindly give me 3 weeks, my lord.
The Lordship kept the matter on 10th.
This matter, yes.
At 2 p.m. Lordship.
No, I can it be on 17th.
17 মানে বিশ্বকর্মা
Subject
পুজো।
to appointment. I can cancel my program because the circuit will be there. That's why, my lord.
তাহলে 17 is বিশ্বকর্মা No,
My circuit will be there. I will cancel that. No problem. I will be here.
17 is বিশ্বকর্মা পুজো লর্ডশিপ।
Then she's come up with Vishwakarma Puja. 10th.
The only thing, Lordship, in 51, my lord, the none appears for the state, Lordship.
বলেননি তো?
বলেন কি সব বলছিস তুই? Get, I shall file.
CAB হয়েছে।
Next.
My lord, I am appearing on behalf of petitioner, my lord. Matter already heard and written notes of submission already submitted before your lordship, my lord.
Concluded last occasion we have submitted our written notes, my lord.
Petitioner worked as head sweeper under Kolkata.
No, probably your senior had
Yes,
to
Mr.
submit
Mr.
something.
Kollal Basu, my lord. Appear, my lord.
Submitted last occasion written.
Yes,
notes.
already written notes
You
submitted, my
said
lord.
that your senior will submit on the earlier occasion.
Not in this matter.
Not in this matter.
Petitioner worked as head sweeper under Kolkata Port Trust.
Oh,
For that matter, my lord.
Ashun.
Only
Then
recovery.
I'll fix it for orders.
Yes, my lord. Only recovery 2,40,000, my lord.
आपको तो written notes दिए थे। What?
I appear for the
26th of September for orders.
Yes, no, my lord.
respondent port trust.
Recovery only 2,40,000.
But I have filed our, we have filed our.
Next.
26
You
September.
only told your senior will appear. Now your senior is appearing in
Notes,
this.
my lord.
Yes, my lord. He's watching.
60.
My 26 September, my lord, for orders, my lord.
Yes.
Yes.
Am I audible, my lord?
Yes.
77.
Sir, you had filed the affidavit in reply on the last occasion, so. Who was representing the respondents?
Last occasion, somebody was there.
Today, no one is there. Ashun. The learned advocate representing the petitioner is present. None appear to represent the respondent Union of India. Let the matter be fixed on 26th of August as last chance.
Last time we make it September.
September?
5th September, 5th September.
5th September is a holiday, sir.
6th.
6th is also a holiday.
7th.
It's also a holiday. 8th. 8th September as last chance. Next.
Should I file written notes of argument?
In the meantime, if you can prepare, then you can file.
78, Milord, I am praying 1 week time to file my written notes of argument, Milord. I am for the petitioner, Milord. Mr. Anirban Banerjee is appearing,
I am for
Milord.
the respondent, my lord.
Kindly give 1 week time to file my written notes of argument. Last occasion, Your Lordship
You
directed.
get,
On
Are
the
you
last
advocate?
two occasions, they
They
did.
did not appear. Are you?
Not advocate.
Then
Mr. Anirban Banerjee is
where
appearing.
is he? I mean, where is he?
He is engaged in another court, Milord.
Okay, so
He,
let him be engaged. Ashun. On the earlier two occasions also, he did not appear.
Milord, he instructed me to kindly give 1 week time to file his written notes of argument.
You ask him to come. Ask him to come.
Milord, he is not.
You said
Probably
he's there somewhere in another court.
he is
He's in
not
other
this court, Milord.
this court. Then which court?
Most probably Alipur court, Milord.
Alipur court.
He instructed me to take time, 1 week time, to file written notes of argument.
Sir, on the earlier occasion also they had come for seeking time, sir.
My lord, last two occasions, they did not appear. My lord, they have, I believe, my lord, they have not filed any notes on argument. And I was not directed to submit any notes on argument. The hearing was concluded.
So will you file any written notes?
If you no, I have not yet filed. If your
I'm
lordship
asking
direct,
you if you will you file?
yes, I will file.
Then
I
you-
have not yet filed because I was not directed. My lord, I will file if your lordship direct me.
Sir, have you seen the record on how many occasions nobody? Sir, you ask your learned advocate to be present tomorrow.
Yes.
Tomorrow,
Tomorrow.
right?
My lord, tomorrow I have some difficulty, my lord.
You need not be there, sir. You have any junior?
My lord, my junior, because tomorrow I am in the other building, I am so many matters, my lord. That's why, my lord, day after
Milord,
tomorrow.
kindly give last chance to file.
How many last chance do you want, sir?
Then
How many last chance do you want?
Day after tomorrow, my lord.
On the prayer of the learned advocate representing both the parties, next date we fix on 21st of August as last chance.
In the meantime, my lord, I shall prepare the note.
Yes, sir.
Rajshekhar Basu.
Yes, yes.
Next. Yes, sir. Are you ready with the list of dates?
Yes, ma'am.
Where is it, sir?
Which one?
So you had to file a copy of the list of dates?
Already given. The last date.
When did you file?
The last date.
আপনি ফাইল করেছেন লিস্ট অফ ডেটস
Huh. That after filing, Your Honor ordered to give copies to them.
we have been served with a copy of a list of
Been
dates.
served with.
Copy served, my lord.
What is your issue, sir?
My lord, this is the order has been issued for reducing my pension 1/3. My lord, I am telling, I joined UCO Bank on 16/5/1983 as agricultural field officer in scale 1. Thereafter, in 1992, I was given promotion in scale 2. In 2000, scale 3. In 2004, scale 4. 2006, scale 6. 2009, scale 7. Thereafter, I retired on 31/7/18. During these 9 years, no promotion was given. The reason is this. My lord, when I was posted at Chandigarh, at that time, bank wanted to initiate disciplinary proceedings against me, including others. Because in the account of Messrs. Medicity Hospitals Private Limited, that proposal I was neither sanctioned nor recommended. So when I came to know that I had taken up the matter of the
To
CVC.
make it cut short, my lord, this is not the issue before your lordship, my lord. If your lordship kindly see the charge sheet, my lord, that is appearing at page.
No, what is his prayer here?
His prayer is, my lord,
Setting aside the order.
Order of?
My lord, that is, my lord, prayer as page 21, my lord.
21st March 2020. 14th June
14 June
2021.
2021, my lord.
And 28th December. This is the inquiry report
My lord.
of 28th December 2020.
My lord. But he never asked for any prayer for, my lord, setting aside a charge sheet, my lord. Charge sheet remains. So he has no problem with the charge sheet.
If my lord, if order goes, then charge sheet automatically goes.
No, what was this order of 14th June 2021?
My lord, my pension was reduced by 1/3.
What was the charge against him?
That is, my lord, your lordship kindly take up, my lord, page 28. That is starts the charge sheet, my lord.
My lord, I am telling.
And
Sir, 1 second.
next page is, my lord, allegation, statement of allegations.
Misconduct.
Yes, my lord. Loan has been sanctioned, my lord.
When did you detect it?
My lord, this is, my lord, the issue is, my lord, if your lordship kindly come at, my lord, page 29, my lord. My lord, first allegation, my lord, as per PBG, at the bottom, second paragraph, as per PBGB policy, sanctioning power cannot be exercised during last 3 months of the retirement. Even the loan of rupees 700 lakhs was sanctioned to Mrs. Eric Technologies. My lord, before at
That was within the period of
my lord,
last preceding 3 months.
last preceding 3 months of
Prior to his retirement.
my lord. In the policy, my lord, it is the specific circular is there, my lord, that nobody can sanction any loan before retirement within a period of 3 months. That is the issue, my lord.
My lord,
And your lordship kindly make a note of it, my lord. That is with regard to the account of Messrs. Eric Technologies. My learned senior friend is indicating, my lord, in other account, my lord. That is not the case is here before your lordship, my lord. So what my learned friend is submitting, well, I just indicate, my lord, the charge sheet is something different.
My lord, why I was telling all these things? Because my record is very good. Only as because I took up the matter with the CVC, and CVC has rebuffed them. No, you cannot initiate major penalty proceedings. So these things the bank cannot swallow. That's why thereafter no promotion was given, and all these things has come. Now, my lord, my friend is telling that Grameen Bank.
Antonu? Okay, take it. Sir, we'll continue after 2. The indicators have already come. After a long time though.
Item number 1, 2, and 3.
Side matter.
I'm appearing for the response. Pursuant to your lordship's directions, we have filed the application. It has been numbered as DA-Com 1 of 2025. It is appearing in the list today. We have already served a copy of the application on my learned friends. I don't know, my lord, if they wish to file an affidavit in opposition.
May it please your ladyship, the application which has been filed is a separate application. It's under 29A4. If I remember it correctly, my learned friend had made a submission that there's a coordinate bench order which is to be brought on record. He wanted to do it through a supplementary affidavit. The Honorable Court was pleased to permit him to file an application through which this will be disclosed before the court. He
So
files
did they
this. He files this petition, and this petition has been served with a. This is an application under 29A4.
My
That
lord,
is our
their first
petition.
title.
Very well.
The
Our
original
petition
site
we have
is
filed.
required.
May I indicate that? There are two main matters. One is where they file an application for recalling of an order of this honorable court whereby an arbitrator had been appointed in a section 11 petition. That is filed belatedly. That is by a section 5 petition. That's the first part of the matter. So section 5 and an application for recalling that order. Second is our application where we have filed an application under 29A of the Arbitration Act where we are praying for an extension of the mandate of the tribunal. So today, the first thing that has to be heard by the Honorable Court in my very respectful submission is the petition that has been filed for condonation of delay. Because once that recalling is rejected, only then this can be considered by the Honorable Court. So today, my humble
What
prayer
they
is
have filed. I have
they
not
file an
yet
application
received it.
under 29A4. So this is
No, they
where
are saying that application is all not on record.
it is not relevant right now. May I indicate this?
There in the list.
Because this is not at all to be looked into right now because first let my friend argue the section 5. He has to cross that hurdle. If that hurdle is crossed by him, then the application for recalling of the order whereby this honorable court was pleased to appoint an arbitrator. If that is considered and allowed, only then this stage of 29A comes. And they file this in my petition. In my petition of 29A, they file an application saying this cannot be entered in by the court. So that's a much later stage. Let them first argue the section 5.
Section 5 application.
Because I'll indicate, my lord, if the section 5 is rejected by your lordship, then the entire matter goes.
No.
Nothing else remains. So let them first argue section 5 because we'll oppose that. We have judgments to show what they are arguing cannot be sustained by the honorable court.
Yes, on the earlier occasion, the earlier advocate had also been present.
Yes,
I had asked him to be present here.
He was there on the last
Hearing of
occasion. And in fact, what I understood from him, just call Nikunj is available. We'll just call him because what I understood from him is he wanted to bring on record a certain number of facts because he was appearing for them. And I do not know why my learned friend has not intimated him because it is their job. They should have
My lord. It's
intimated.
recorded in the order that we have intimated him, my lord. Wrong submissions are being made, my lord.
There's no wrong submission.
All
You should
three
have got
matters
them.
which are appearing are their applications. In their applications, we have filed review application in one.
My application, I'm
Now,
sorry.
will you please put an end to this? Now tell me. The section 5 has been filed by
him. Let him move it.
My lord, my section 5 application is for condonation of delay in filing the review application in the first minute. My lord, in this case, what had happened is there was an earlier order where the court had held there is no jurisdiction. My lord, in spite of that, they filed a second application. That previous order was suppressed and an order was obtained from this court as if there is no dispute on jurisdiction, in spite of our client's written instructions to their lawyer that the jurisdiction is to be contested. Now, my lord, we were unaware of this order because it was not communicated to us. When we came to know of this order, we first wrote to our advocate asking for an explanation why
You can very well do that out of the court, sir.
we had asked our advocate to give an explanation. He gave an explanation which was not satisfactory to our client because of My lord, the specific thing that they had.
Sir, I have heard this
Yes, ma'am.
a number of times.
Yes, ma'am. My lord had indicated that your lordship would like to hear that advocate for his explanation of this, because my
So no,
condonation.
because everything uh, hinges upon his declaration that he was not asked.
Yes, ma'am.
But he, in the order, in that email, there was an email,
My lord.
and thereafter, you are banking on that email.
Yes, my lord. Yes.
But they did not mention about that email to the coordinate bench.
Yes, ma'am.
If at all there had been
Yes,
one.
ma'am. That is the crux of the matter. Both my
On the
section 5.
contrary, they have said
No dispute.
that also a senior advocate's name appears.
Yes, ma'am. Let me direct us to serve, because we had served, he was there, my lord had directed him to come again. But he has not come, my lord, we can serve him. We have served, we can give him a notice again and.
May I humbly submit this?
Otherwise, how can your, I mean, if at all, your delay is condoned
Yes, ma'am.
for filing the review application. So how can we proceed further without his presence?
Yes. It is required, ma'am, to have his explanation, whatever it may be. It has to be, my lord, before your lordship.
Whether he has to submit an affidavit, whether he has been directed or not.
I appreciate.
And this cannot go on for, I mean, it cannot go till eternity, the way you people are there, and it will affect both
It's
of you.
affecting us, not them. It's affecting us. Definitely not them. We are the claimants in the arbitration proceedings, so it will affect us, not them. They want to prolong the matter. That's the difficulty.
My lord, I also have a counterclaim against them, which is
Which
more
they don't
than
want
the
to,
amount
which they don't want to proceed.
Mediation.
It's going to fail, my lord, because the arbitration, they have tried everything under the books to, my lord, stall the entire process.
Because they have come to the wrong jurisdiction.
Definitely not. They should have
Entire
taken
tender
this
was in
point. They have
Mumbai.
never taken this point. Let them argue that. I'm ready to face the
On
argument.
this issue, if we go on for days together.
But may I submit this? And this I'm submitting as an officer of the court. But if the condonation is being argued by my learned friends, if they want to make that submission, I'll only indicate.
I also had asked you to contemplate out of court whether you can get it done.
My lord, we have
We
given
are
them
not
a
agreeable.
formal
I've taken
letter.
instructions.
Then
They are not
they have
agreeable.
not even communicated them that they are not agreeable.
There's no requirement for communication because I'll indicate what they have done, which I did not want to indicate.
In any ways, you have to ultimately resort to arbitration.
We have to, my lord. And that is why the arbitration is ongoing. That's the problem. The arbitration is ongoing. From the order by which the arbitrator was appointed by this honorable court, it is very clear. There are two paragraphs I had shown on the last day, my lord. First paragraph is a concession of both the parties on one point. There were 3 arbitrators in the agreement. The parties conceded that we'll go before one arbitrator. So there will be a sole arbitrator. That was the concession.
Where is your section 5 application?
And my section 5 application GA number 2507 of 2018. Original.
No, again, section 5 tab.
2507.
Well, so far as the arbitration is concerned,
Where have you explained in which paragraph?
my lord, my explanation.
That also you have to come and find here, sir.
There is none, madam. I'll indicate.
Big page.
There is none.
Sees the
26
sequence of
is the
events.
paragraph which will show,
Well,
and I'll
para
indicate
five.
that's not the explanation. That cannot be the explanation.
Para 5, my lord, we have given the sequence of events that led to, my lord, the delay. May I, my lord, place it? For for the purposes of representation of the petitioner, original.
Perhaps have redrafted the entire thing in your section 5 application.
Well, the sequence of events, my lord, is, my lord, given A, B, C, D sub, my lord. Page 6, my lord, para 5 start. Page 6.
Now, have you got to say anything?
Your lordship is with me, my lord. I'll not say anything, my lord. But if your lordship is, my lord, please to dismiss this, because I'll indicate otherwise factually that there's no reasoning. I have two judgments, my lord. I'll quickly indicate in 5 minutes. Because this I'll indicate. Your lordship, kindly bear with me for 5 minutes. On the condonation, my lord. The order which they are, my lord, basically assailing is, my lord, 6th of February 2018. Now, my lord, this petition was formed on 3rd of September 2019. There's a delay of 209 days, not 116 days, which they have not prayed for. Now, my lord, the reasoning that they have sought to be given, my lord, is paragraph 26, where they say, I'll read it out, my lord, kindly bear with me. Says the aforesaid delay in filing the application occurred due to inadvertent, my lord, this is internal page 34.
Yes.
The aforesaid delay in filing the application occurred due to inadvertent circumstances entirely beyond the control of the petitioner or the original respondent. And in spite of all due diligence on the part of the petitioner, original respondent, there has been no intentional delay or latches on the part of the petitioner, original respondent. The petitioner, original respondent states and submits that the petitioner, original respondent has all along acted diligently and faithfully contested the case, and there has been no latches or negligence.
This is the conclusion that they have
That's
made.
because, my lord, there is.
In the initial paragraphs, they have
My lord, paragraph,
elaborated.
kindly, it's
But
summarized
kindly
in
see,
paragraph
I'll
19.
indicate.
Kindly see. I have explained why after the order I could not file on time. Para 19.
I'll indicate paragraph 19.
Page
Kindly
27.
see. If my learned friend is relying on that, it's a longish paragraph, 3 pages.
Respondent was completely unaware of the order at that time.
They participated and they say I was unaware.
Saying
Lord,
my
kindly
advocate
see,
has
I'll indicate, my lord. Kindly see what is the flow of events. My lord, this,
That I have seen. Let's not go into this.
my lord.
I've seen that.
And after that,
My lord,
my
here
twice-
my only contention is this. My lord, 6th of February 2018, they asked for recalling of an order, which is in March, 8th of March 2018. They filed, my lord, on 4th of June, that was GA 1325 of 2018. So that was a 95 days delay. That was, my lord, GA 1323 of 2018. This was dismissed on 10th July. That order, your lordship will find at page 83 of this petition. It's page 81, my lord, where this was dismissed. Now kindly see, my lord, how it has been dismissed. My lord, kindly take up that order once. I'll indicate this is for a reason I'm indicating this.
Which
my lord.
page?
Page 81. 81, my lord.
Yes.
In these applications, the applicant has prayed for recalling of the order passed in by this court in AP 44 of 2018, appointing arbitrator to adjudicate disputes between the parties after condonation of delay. It appears that the applicant has filed the application by disclosing a copy of an application containing various comments or markings. That's their petition, my lord. It was submitted by the learned counsel for the petitioner that the copy of the application served upon the petitioner contains such comments or markings. However, considering the averments made in paragraph 5 of the application, it appears that such comments made by the learned counsel for the applicant is totally unfounded. That's against the lawyers which were made, my lord. Accordingly, this application and this number are dismissed with liberty to file afresh, and then with this liberty, they file again on July 27, 2018, containing the same averments again. And that, my lord, was again considered at page 83, my lord. Same thing they do again. And may not kindly see how the court deals with this. This is 24th August 2018. In this application, GA so and so the petitioner has prayed for condonation of delay of 107 days to file the application for recalling of the order of February 6, 2018. Admittedly, copy of AP 2018 was served upon the respondent in the said application, being applicant herein, but the application does not mention the date on which it was received by them. There is no verification about the date of receipt of the said application by the applicant. At this juncture, Mr. Das prays for leave to withdraw this application, and leave is given because to file applications with proper pleading. That's the recording, my lord. Now, after this, my lord, kindly see in my very respectful submission, this application is then filed. That's recalling and the COD, my lord. COD is this application with 209 days delay. Your lordship will find the reasoning is missing. That is my submission. The previous is only the facts given. Only facts. This is what has happened. The reasoning, if my learned friend says it's paragraph 19, kindly take up that paragraph once, my lord. It's from page 27. Give it those two judgments, Mulchand and Radha. Paragraph 20. When the order dated February 6, 2018 was passed by his lordship of this honorable court,
Reiterated the same thing.
only the fact, the same thing, my lord. So, my lord, what is the reason for delay in filing the petition? There is no cause. My lord, the contention is that there should be sufficient cause explaining day to day that this is what may not be day to day, my lord, phase by phase, this is what the delay is for. There is no explanation. On this basis, the only way, my lord, they've tried to explain is paragraph 26, which I've read out,
No,
where they say no intentional
come to
delays.
page number 29
My lord, I'm in page number 29, my lord.
from
However, on May 28, my lord, is that the portion your lordship?
from immediately thereafter. Thereafter, they have at least tried to
Pin the blame on the
something,
erstwhile lawyers.
compelling circumstances such and such. However, on May, received a reply
From its erstwhile lawyers, and the contents of the said reply
to
became
alleged
amply clear.
non-payments, such and such.
No intention to protect the legitimate interest,
from
contrary
there-
to records, interested only in denying that they had contested on the issue of jurisdiction. Now, I pause here for a moment. This is where, my lord, I want to join issues, because today, a bare perusal of the order would reveal that there were two portions of the order, my lord, and that is why, my lord, I have to indicate this. This is not a reasoning. I'll indicate why. Kindly bear with me, my lord. The order impugned, my lord, where they want a recalling of, is, my lord, in two parts. The first part is a concession of the parties where, my lord, this, what they're contending, that I had given instruction to my lawyers did not follow the instruction. That cannot be, my lord, because the first part is a concession on the number of arbitrators. The second part on jurisdiction, what they're saying, is a finding of the court. I'll kindly bear with me for that 1 minute. I'll indicate that order. Show me. But kindly take up that order once. At page 38 and 39. Let may I only indicate page 38 once. This is the order of which they want a recalling. Let kindly take up page 38 once. And this will clarify things, my lord. 38, my lord. Page 38. My lord, 6th February 2018, my lord. Kindly see the second paragraph. Petitioner has prayed for an order of appointment of an arbitrator for
first order.
This is the order, my lord, of which they want a recalling. This is the order, my lord. Kindly see the first paragraph of this order. The petitioner has prayed for an order of appointment of an arbitrator for adjudication of the disputes between the parties relating to contract dated January 14, 2015. Existence of an arbitral agreement between the parties contained in clause 7.2 of the contract. Further, there is no dispute between the parties with regard to jurisdiction of this court to entertain this application as a part cause of action of the petitioner to file the application as arisen within the jurisdiction of this court under section 11. The learned advocate appearing for the parties also submitted that instead of appointing 3 arbitrators as contemplated under the arbitration agreement contained in clause 7.2 of the said contract dated January 14, 2015, The parties are agreeable. My lord, kindly mark this. So this is where the parties were agreeable to. Parties are agreeable to the appointment of a sole arbitrator for adjudication of the disputes relating to the said contract. Now, over the page, my lord, page 39. Accordingly, so and so and a senior advocate is appointed as a sole arbitrator to adjudicate the disputes between the parties relating to the said contract. The learned arbitrator is requested and the consequential orders. So, my lord, finding of the court in the first paragraph with regard to jurisdiction is a finding of the court. If they are agreed by it, they should have challenged this before the Honorable Supreme Court. They have not done so. They come and say we had not given instruction to concede. Concession is in the second paragraph, which is only limited to the number of arbitrators which the court appointed. So that explanation, my lord, if it is corroborated in paragraph 19, what they've stated, my lord, is not cause at all and not sufficient cause, definitely. I'll indicate, my lord, one Supreme Court judgment on this point, Moolchand, which settles the issue. 2025, my lord. A better copy. You have a copy for them?
What is the stage of the arbitral proceedings now?
My lord, pleadings are complete. And my lord, thereafter they had filed this, my lord, application, which is pending. So, my lord, the arbitral tribunal is in a limbo now. Because, my lord, that period of 6 months is gone, 1 year is gone, my lord. So we had filed that application under 29A, by which, my lord, it falls on the honorable court to extend, my lord, the time for the tribunal to, my lord, complete the proceedings. So, my lord, it is at that stage. I had also taken instruction, since it had fallen from your lordship, whether, my lord, the arbitral tribunal and everyone can go and do it. But my instructions are very clear, because that's, my lord, what they had not pointed out ever. So, my lord, they have not given us the proposal, and my instruction is also, my
Can't it be done online?
The witness action and the entire proceeding cannot be done online, my lord, because that's the difficulty which we are facing in other arbitrations also, my lord. And the learned arbitrator, my lord, is a senior advocate.
You have to come to a consensus.
I don't think, my lord, that's being possible. That's the difficulty, my lord.
My lord, my learned
I have
friend was
tried,
not
my lord.
here. He's changed brief. Before the coordinate bench, we had submitted our only issue is not with venue, it's with the seat, because the legal seat of the arbitration should be in Mumbai. There was, my lord, several dates the matter was fixed for settlement. Initially, before the learned honorable coordinate bench, they agreed. We drew up a terms of settlement. Then they came and said, no, we are not agreeing. We agreed that the same arbitrator will continue, only the legal seat will be in Mumbai. Now, my lord, that is why it was released by the previous coordinate.
I tried. It's not that I did not try. I did try. But, my lord, there's some difficulty, I understand, because also, my lord,
Okay, which
paragraph 20, my lord, of Moolchand. It's page 10, page 12, my lord. I'll only indicate the relevant portion of this judgment. Page 12, paragraph 20. Take out the next judgment.
Page?
At page 12. At the bottom, my lord, the page number is given. Page 12, paragraph 20, last 5 lines. Your lordship will find it starts from, it is not the length of the delay. Your lordship has found that, my lord? Paragraph 20, my lord. It is not the length of the delay that would be required to be considered while examining the plea of condonation of delay. It is the cause of delay which has been propounded to have been examined. If the cause of delay would fall within the 4 corners of quote unquote, my lord, sufficient cause, irrespective of the length of delay, the same deserves to be condoned. However, if the cause shown is insufficient, irrespective of the period of delay, the same should not be condoned. Now, this, my lord.
What is your prayer in the main writ petition? I mean,
Section 11, my lord, was for appointment of the arbitrator. That was allowed.
yes. And then subsequently?
Subsequently, my lord, they have now filed for recalling of that order, the order which I had, my lord, just read out, page 38 and 39. They want, my lord, so they should have, if they are agreed by that order, they should have appealed against it. They did not. And they filed this in a nature of a recalling, which is in the garb of a review, which could not have been done, because there is nothing ex facie, my lord, prima facie, there is no error in law. Now here, my lord, the explanation that they are relying on, paragraph 19, cannot really be an explanation, because, my lord, there, all that they have stated is the flow of events in the section 11 proceeding. They say this is not what has happened on merits. So if that is the case, they should have challenged the order. Nothing stopped them from challenging the order, my lord, before the Supreme Court.
Okay.
That's my contention. My lord, one more judgment may I only rely on. This is, my lord, State of Uttar Pradesh and others versus Satish Chandra Shivare, 2022 Supreme Court. 2151. I'm relying on paragraph 18. And here your lordship will find in paragraph 17 and 18. Sufficient cause has been explained. Here what is laid down by the Honorable Supreme Court is on the point that even the government cannot, my lord, escape this sufficient cause with any red tapeism, anything, my lord. So that's paragraph 17 and 18 that I'm relying on. 18, my lord, quotes from Basavraj, the sufficient cause explanation is given. My submission is, my lord, sufficient cause has not been given at all. No cause has been shown.
My lord, he has argued on merits also, but let me just confirm the condonation once. My lord, has seen in paragraph 19, I have explained the detailed reasons why I filed the first application after 95 days. My lord, the first application was filed on 4th of June 2024. First sitting of the arbitration happened on 25th June. So it was before the arbitration started, I had already filed. Now, my lord, this petition was pending. When it was heard by this court, there were technical defects. There were some comments written on the annexure. So I was given liberty to file afresh. So the period that this matter was pending before the court under section 14 of the Limitation Act gets excluded because the matter was pending. Then I was granted liberty, but I filed again. There was again some technical defects. That was again, my lord.
My learned friend should be
kindly
submitting
sees
that it's
my lord, I have not
technical defects,
interrupted him
these are-
once.
no, I'm not-
This is
sorry,
not the way
sorry, I'm
to
not
my lord
interrupting
make-
you. It's just that my learned friend should indicate that these are not technical defects. These were allegations against the lawyers which were ill found by the
My lord,
court.
kindly seize that order.
Sir, I've seen.
Yes, ma'am.
Let us conclude it now.
That I
I
said
also
that
hand over Basavraj, my lord, the judgment which I just referred to, paragraph 9 to 15, which is quoted, my lord, in Satish Chandra, my lord. Paragraph 9 to 15, my lord, of this judgment.
No, this is GA number. The
GA5.
5, my lord.
5?
Old number 2507.
GA5, my lord.
এখানে তো GA5 বলে কিছু বলছে না। আচ্ছা, GA2507 আর old number. আচ্ছা।
GA5.
Okay. For the
2008.
submission of the learned advocates representing both the parties in connection with the application being GA5 of 2018 as well as GA6.
The GA6 is the recalling petition.
Main petition.
No, GA5 should have been. Next date be fixed on 1st of September for orders.
Very deep. Very deep.
Item number 4.
Last stated, was your lordship's pleasure that I hand over notes of argument.
Sorry, sir.
That I hand over some notes of arguments. Your lordship's, it was your lordship's pleasure that I hand over the notes of arguments, and that has been done. I've prepared it. Case of compassionate appointment.
Yes, sir.
But just now I've received the notes of argument, Lordship.
So what?
I have to go through these notes of argument, Lordship, and I have to prepare the another notes of argument for myself, Lordship.
You won't submit?
Lordship. Submit, Lordship.
Tell me in a crux, what is your contrary view?
But just now he has just served, Lordship. But only view is that, Lordship. Kindly see, Lordship, my availability in opposition, Lordship. At the time of death of the Lordship, father of the petition, Lordship, the deceased employee, Lordship, there is a rules regarding compassionate appointment, Lordship, that he should pass the 10 standard, Lordship. And Lordship, prior to that, Lordship, this is the second round of litigation, Lordship. And first round of litigation, Lordship, the Honorable Court, Lordship, directed the respondent bank, Lordship, to consider the representation. Against that, Lordship, we have preferred an appeal before the Honorable Division Bench, Lordship. Honorable Division Bench, Lordship, kindly see the order. Honorable Division Bench directed the bank, Lordship, if there is any appointment with regard to any compassionate appointment, Lordship, then he will get the privilege, Lordship. Lordship will find the order, Lordship. Appearing at page starts from 72.
72 of?
72 of the writ petition, Lordship. And Lordship, Lordship, kindly go through page 80, Lordship. In the second paragraph, Lordship.
82?
80, Lordship. 80 of the writ petition, Lordship. Under the circumstances, we direct the competent authority to reconsider the prayer of the writ petitioner as to whether the recommendation of Khandial Committee was actually implemented by the bank prior to 31st May 2016, and in the event it was implemented and applied to persons similarly placed as that of the writ petitioner, to extend the benefit of the recruitment policy of 22nd October 2005 to the writ petitioner. We are making this observation in view of the fact that in the resolution dated 29 June 2016, the Board of Directors noted and approved the revised recruitment policy, which gives an impression that the recommendation of the Khandial Committee earlier may not have been implemented. There is nothing on record also to show that any revised recruitment policy was formulated prior to 31st May 2016. The entire exercise shall be completed within the period of 4 weeks from the date, Lordship. Thereafter, Lordship, we pass the reasoned order, Lordship. Lordship will find the page 83, Lordship. Starts from in deference to the solemn directions of the Honorable Division Bench, Calcutta High Court, feed its judgment and order dated 21st January 2020, passed in GA number such and such. The competent authority of the bank has Lordship has examined as to whether any appointment, Lordship. And against this order was challenged by Lordship, my learned friend, before the normal court, Lordship.
How long will you take?
Lordship, at least 2 weeks, Lordship.
Written notes of argument filed by the learned advocate representing the petitioner be kept on record on the prayer of the learned advocate representing the respondents to file the written notes. Next date. Eleventh of September.
Date, Lord.
Item number 5.
My lord, I am for the respondent number 225.
We appear under the state respondents.
Where is the petitioner? Nobody is representing the petitioner.
Mr. Partha Ghosh. This issue has been settled by the division bench. Probably that is why the petitioner is moved.
I just wanted to know whether the petitioner has claimed, the petitioner has claimed that they are governed by the division bench order.
This petition, my lord, has been was prepared in the year 2018. The division bench has dealt with the issue in the year 2024, my lord. 2024. I had submitted, my lord, the judgment. I had also informed Mr. Booth was appearing at that time. I had also given him the copy of the judgment. Thereafter, my lord.
Acha. You are representing, madam?
Respondent corporation, my lord, respondent number 6.
One.
5.
In fact, on the earlier occasion also, I did not hear him. He did not appear. I mean, before this court, he did not appear on any occasion.
He appeared once when when I had changed the judgment.
When?
It was probably in the year in the month of February.
But this good.
I don't find his presence to have been recorded.
My lord, it is 4th of December 2024.
4th of December.
None appear to represent the petitioner, the learned advocate representing the respondent. Corporation?
Yes, ma'am.
All of you are representing the corporation?
We appear on behalf of the state respondent, respondent number 1.
Corporation, respondent corporation as well as respondent number 1 state are present. Next date be fixed on 12th of September. Prior to that, as last chance.
Much obliged.
To continue. To continue actually.
Item number 8. And CBC have not accepted their severe recommendation. They were annoyed with me. And I was posted on 20 search for the grabbing facts.
I mean, at that time, bank was in shambles. And on my concerted effort, the rating of the bank was substantially increased. And NABARD and RBI has appreciated. And NABARD has sanctioned a cash reward of 1.5 lakh per month. All these things are given there. Now, after 2 years of retirement, this memorandum was issued. And what? And they are actually regulated. I have looked at only the except after Regulation 19, consultation with Central Business Commission. Bank have consult Central Business Commission whatever necessary in respect of all drinking cases at the time. That is, my lord, it is compulsory that bank has to consult Central Business Commission. Now, Central Business Commission has given direction. Kindly come to my page number 13. My quick notes of argument. There I have given the text.
Yes. Yes, consultation with CVC.
CVC. Kindly come to the page number 13. Last but one, item number 3, last but one line. Therefore, a copy of Commission's first stage advice may be made available to concerned employee along with a copy of the charge sheet. Charge sheet served upon him for his information. Yes. However, when the CPC suggested advice is obtained, a copy thereof may be made available to concerned employee along with the IO's report to give him an opportunity to make representation against the IO's findings and the CBK advice.
So you did not get these report?
No, it was not given to me before issuance of the memorandum. It has to be given first week advice. It was not given. When the inquiry report was sent to me for my comment, then also they have not given. So they have violated their own regulation and CBC guidelines. My lord, thereafter, the investigation was report was given in September 19, on the basis of which this memorandum was issued. So 6 months time was there, but they have not taken CBC first stage advice. So without first stage advice, they have issued the memorandum. Now, inquiry was held. Inquiry was held in a perfunctory manner. They are going to do so all inquiry proceeding. Management documents and management document was to be produced by the witness. But here it was not done. I might not kindly come to page number 21 of this regulation. Regulation 613. It is only date fixed for the inquiry. The oral and documentary evidence by which the articles of charge are proposed to be proved shall be produced by or on behalf of the disciplinary authority shall be examined by the presenting officer. The witnesses produced by the presenting officer shall be examined by the presenting officer and may be cross-examined by or on behalf of the officer.
So you were not allowed to cross-examine?
No, cross-examine, how? Because the document was produced by PO himself. So there was no cross-examination. I have lost the opportunity of it is the natural justice. I am giving on judgment. Supreme Court recent judgment. It is 25 INST 565 and this judging in the month of April.
My lord, it is that judgment on the last occasion, the same matter, Mr. Mojumdar relied upon, your lordship. I will clarify, ma'am.
Here also it is applicable.
Mr. Mojumdar was arguing same matter, same account, same thing.
No,
Three,
not said.
three petitions are there, my lord, analogous.
Okay, we will continue with this on the next stage. You also come prepared.
Only, my lord, just to give a reply short, your lordship kindly come to paragraph 20.
Next stage, sir.
Fine.
Next stage. At the submission of learned advocate representing the petitioner.
Whatever.
You had filed the written notes, right? Learned advocate representing the respondent bank. You want to file notes?
I want to file, ma'am.
Intends to file the written notes. Same is allowed.
I have already submitted.
Next date we fixed on 17th of September for final hearing. You conclude along with your
17th September, Vishwakarma Puja is there.
Oh, 18th of September. Though holiday, I mean, High Court is.
There is no holiday, my lord. I know, my lord, but
holiday.
some
19th.
19th. Next.
81.
But before your lordship takes up the matter, I would like to indicate that there was a direction upon your lordship after hearing me that
Who's appearing for the bank?
I am for the
my
bank.
lord, that on the last date I had pointed out that pursuant to an inquiry that I had conducted against
Did you serve notice upon
this could not
respondent?
be served because there was some problem with the postal services. Some problem. I believe it has been cured now.
Postal services was stopped.
Servers were down. The servers of the postal services were down. So I think it has affected the general public at large. So we could not take any steps to serve. Lordship will give me the liberty to serve. Gives me a short date, I will come back. It was not in my hands that I could not serve him. He is relevant. I'll tell you, Lordship, why. Because my contention is...
The respondent number 9 is the answering respondent.
No, the answering respondent is the bank, but he is the complainant on whose complaint I was dismissed from service. My allegation is...
Just tell me for my recapitulation.
Very
What is
briefly,
it?
Manoj, I was entrusted to conduct an inquiry in respect of two branches
Yes.
over which the private respondent
Vijay or
Vijay
Kumar.
Prakash. Lord, I say I have been victimized because I went against him and I submitted a report against him. There is also a development. I'll come back with a supplementary affidavit to that effect.
No, I mean, the situations as mentioned here doesn't really say that you are absolutely.
But I will show from documents, my lords. I'll show from documents. Not everything will be clear, and I will also point out the conduct of the bank. They ask me to investigate a gentleman. I submit a report against him with caustic remarks against him, with categorical findings against him. At his instance, I am dismissed from service. I believe he is in a much better position now. That I believe, my lord, that casts some aspersions with respect to my learned friend.
But
on
there
the
was
conduct
an
of the bank.
assurance that if this
I have never given him
I will show my lord 3-4
any
documents.
assurance.
3-4
My lord,
documents.
the development is
there
he
was
lodges
an
a complaint.
assurance that you can be exonerated provided you. Yes?
Yes, my lord.
Yes, isn't it so?
Is it?
Yes.
Well, I'll satisfy your lordship even on facts that no case is made out. And there is a glaring development. He lodged a complaint
Disciplinary
against me,
proceedings,
though
my
I
lord,
know
in a
that
judicial review. Scope
acquittal
is
in
very
a
limited.
criminal proceeding is not per se as a
It is
matter of
not
course
required
will not
to
exonerate from
prove
disciplinary
beyond
proceedings.
reasonable doubt.
But if your lordship would see the conduct of this private respondent, Mr. Srivastav, that he lodges a complaint, he does not even appear to be examined before the concerned court, for which I've been exonerated all the criminal charges. I know, my lord, there are body of case laws which does not give me that benefit of the doubt. But there are also a body of case laws which give me that benefit of the doubt. And Lordship, this matter will turn on the facts of the case. And the most vital fact being the complaint.
Do you want the evidence to be reappreciated?
No. Malad, the appellate court's order is an absolute, is a rubber stamp order. Your Lordship are aware of those body of case laws where I can just, I mean, it should be set aside for asking, if you ask me. But I am more concerned with my order of dismissal. The appellate court in 10 pages just records the submissions, in one line dismisses the appeal. But I believe, Mr. Srivastav, subject to whatever falls from your ladyship, it should be heard by your ladyship. And also I will request your ladyship to appreciate the conduct of the bank against not taking any steps against a person without holding the report that I have filed is bad in law. I am called upon to investigate a person who is the private respondent herein, Mr. Srivastav. I file a report against him. I communicate it to my senior. After that, the allegation is I have allegedly, through someone else, called upon him to pay me some money. After I submit the report to my superiors.
Only short reservation, my lord, not bank, my lord. He should have any, if any objection against the disciplinary authority.
It is that Srivastav who probably had given that assurance to dilute.
Not Srivastav. It is the assurance was given by one Guddu Kumar. He is not in the proceedings. My lord, may I file, my lord, opposition, my lord? It is already served, my lord. From that.
Right
It is
there.
not.
Reply file it. I will pray for a liberty to file a supplementary affidavit to bring
My lord,
on
before
record.
hearing, there is no scope of any supplementary affidavit.
My learned friend files his affidavit in opposition. Copy has been served on.
Reply already filed.
Long back. Reply copy there. Reply, I believe, we filed the reply.
Pleadings concluded, my long back, my lord. It is lying with the advocate on record, my lord. He could not. Reply already filed, my lord.
Affidavit in opposition filed by the learned advocate representing the respondent bank be kept on record. How long will you take to file the affidavit in reply?
Well, I file my reply. But this is
reply already filed.
later.
It is
pleadings have
lying with the advocate on record because only this, that is why we could not file this.
The reaffirmed copy?
No. So, your lordship, kindly see the affidavit portion, my lord.
It's of 18th February
It is
2022.
affirmed on, my lord.
Then why, when did you file your reply?
I have filed my reply. I have the scanned copy. It's
affirmed
filed on
copy.
4th April 2022.
Affirmed on 18th February 2022.
I am told the reply forms part of the court's records.
The affidavit in reply affirmed on
4th April 2022.
4th of April 2022 and already been on record.
I'm praying liberty to serve him afresh, the respondent number 9.
Yes.
Also praying for liberty to
Learned
file a short
advocate
supplementary
representing the petitioner submitted due to certain glitches in the postal department. It was not possible to serve notice upon the respondent number 9 in compliance with order dated 22nd of July 2025 passed by this court. The learned advocate representing the petitioner is to serve a fresh notice upon the respondent number 9 intimating the next date of hearing and file an affidavit of service.
May I prefer a short date subject to my lord's kind consideration. I'm out of service, my lord.
19th of September.
I'm so grateful.
Next date be fixed on 19th of September.
I'm grateful, lordship.
No, okay, কত নম্বর ছিল? না আগে
$21.
This matter is led by Mr. Saptanshu, senior advocate. He's in bar room right now. He's just having a voice conference to the Jalpaiguri bench. He's just asking for a short passover, one matter passover. He's coming.
No, then it won't be possible.
But Milots, he is just right away, Milots.
Today is the date fixed for the inspection of the record by the Honorable Court. Yesterday, what has fallen from your lordship that the court will inspect the records. GSFC.
So then he's not there.
Ma'am, he's coming. Just one matter passover I'm requesting. That's all, Milots. He's ma'am.
Sure.
On legs, he's no matter. Kindly keeps a short passover, my lord.
Then you come after 4:30.
Tomorrow, kindly take it up tomorrow.
4 p.m.
No, আমার হবে না। এই সারাদিন একটা ম্যাটার নিয়ে এসো।
3:30 today. He's on legs, my lord. He was here only.
না আমার মক্কেল আসবে সারাদিন একটা ম্যাটার নিয়ে।
Not a short passover, maybe. He's just on his legs.
Yesterday also I gave
Yes.
due time.
Yesterday, my lord was of the view that my lord will inspect the records in presence of both the parties.
I
Keeps
can't
a
grant
short
you
passover, my lord.
today.
I'm praying for a short passover, my lord.
The learned senior advocate being engaged elsewhere. Let the matter be fixed on 29th of August. Next.
My lord, kindly keeps it on the first week of September.
Next date be fixed on 21st of November. Next.
21st of November.
My lord, we have some hurry in this matter.
Kindly.
So just see their
His writ petition in 2021 and enjoying an interim order, and he is going to retire.
My lord,
We cannot execute the award also.
also, madam. Next.
Obliged.
Huh? 12 হয়ে গেছে 12টা হয়ে গেছে
Pursuant to your lordship's order, my lord, on the last date, my lord, they inspected the file, my lord. Original file is with your lordship's custody.
My lord, we have already covered the factual aspect. We have already covered the factual aspect. My lord, today, we shall examine, my lord, the decision-making process. The process of making the decision.
So you had inspected the record.
Yes, we have taken inspection of the records. We have taken inspection of the records. I shall address your lordship on that. When you come to the Milord, the decision-making process, Milord, we shall have occasion to refer to the records, Milord. At the appropriate time, I shall refer to the records, Milord.
Hey, Shantanu. Both of you, can you come back tomorrow? Because there are many FMA orders to be dictated.
Yes,
sir,
yes,
today.
my lord.
I leave it
It
to
will be better, brother, because I also was, my lord,
all depends
thinking-
upon the court's convenience. Provided my lordship can fix a particular time, subject to your lordship's convenience.
I'll fix it up at 2 p.m. But sir, I can't assure you that it will be taken exactly at 2 p.m.
No, if it is taken up in course of the day, Milord, then it's all right. We can certainly afford to wait, Milord. Instead of 2 p.m., it could be, Milord, 3 p.m., no problem. Court's business.
The learned advocate representing the petitioner as well as the respondents are present. Let the matter be fixed on 20 August at 2 p.m.
Milord, one thing Milord, I think it's clearly understood that if somebody is missing from the records, Milord, if something is missing from the records, Milord,
something is missing, my lord, from the records, my lord. Later on, my lord, no attempt will be made to supplement it. Supposing, my lord, some paper is not there, understand, my lord, that is the understanding of a learned friend. There will be no further attempt to supplement it or produce it at a later stage. These records are the records of complete proceedings. These are the,
To you, the record is incomplete.
according to me, it is, my lord. When I come to that, I shall try to satisfy your lordship. But the question is today, my lord, later on, no further attempt be made on the part of the respondents to say that we are now giving further documents, the further document,
They cannot create any document any further.
No, if something, the document is left out, I don't.
I believe in that case also.
Very well.
You can indicate which are the documents you feel that are not there on record.
That will, she will say at the time, at the time we make the submission.
Yes, kindly give a list that these and these documents I require necessarily, my lord, I will try to
cover and then submit.
Next.
Court proceeding, obliged, my lord.
16, my lord, Mr. Mudra is at the morning, my lord, not good.
Yes, sir.
My lord. My lord, this argument a matter, my lord, since morning, my lord, before the honorable listener.
What is it, sir?
For a petitioner before my lord was appointed in the CRPA. At the time appointment, required qualification was class 8 pass. Unfortunately, petitioner went up to class 10 board, there he failed. He submitted the fail certificate. Mark sheet and certificate, he failed. The recruitment was done in Sainthia Birbhum. There are some Bengali officers there. They says, yes, since you are a regular candidate, you have failed 10, but you have 8 pass. Taken. He was taken into employment. Then he was sent for training to Hyderabad. After few days of training, the authority says there is no class 8 pass certificate. He said that, no, that will not do. Fail will not do. I want a class 8 pass certificate. You tell your father, mother who is about it, let them send a class 8 pass certificate. So he wrote a letter to his father. His father went to the headmaster. When he started, headmaster said, no, if nobody understand, I will not give sure certificate. He as a regular student, went up to class 10, means yes, class 8. I will not, they did not give him. So then I go to any high school, bring a certificate. He go, his father, old man, my lord, say one school to another. One school gave a certificate. He sent it to the respondent, to the respondent, sent to the petitioner, it deposited. He says, yes, your certificate has come, so you can continue training. Everything all right. Training over, he was continuing service. On completion of 20 years of service, he wanted voluntary retirement. He submitted application for voluntary retirement. Then he says, no, you are appointed on a fake certificate. That's the case, my lord. Initially, that was.
From whom did the father procure that certificate?
One school, my lord, high school.
One school means from any school where he had not been a
No,
student.
that school refused to give. And my lord, because of
If a particular school in which you had been a student.
No, not that school. My lord, the authorities of the
sir?
training center, my lord, they don't any, they says anyway class 8 certificate is required.
So anyway means like
They says, my lord, one poor fellow has got an employment with a class 10 fail. He got an appointment. They want any certificate. He has given any certificate, class 8 pass.
Any certificate?
Any school, they said so. So you bring any certificate from any school. We want class 8 pass. We want class 8 pass. But facts remain, my lord. If they, at the time of recruitment,
student issue a certificate in your favor.
My lord, at the time of recruitment, I have deposited class 10 fail, board fail, medical admit card and certificate. That was admitted. Later on, they are asking any place, where from he can get? Either he has to lose his job or he has to collect. They are compelling to collect. They are
compelling to collect. You could have stated that I'm not in a position to produce.
My lord, come to paragraph 10 that we said West Bengal Board of Secondary Education has issued him a certificate. Page 9, my lord, paragraph 10 of the petition.
What is this? A means absent.
Class 10.
No, you had been absent. A means what? Absent.
No, not absent, my lord.
Then what? I don't think in the year 1982, West Bengal Board of Secondary Education used to issue this kind of mark sheets without any marks. A means absent, I believe. What is this? This itself appears to be fake.
My lord, that they have been inquired. There has been police verification before confirmation. Police verification is done. Everything was verified. But everything was verified. After verification only they have given the appointment. But only training the problem created. "20 years after completion of 20 years of service."
He was dismissed.
My lord,
He was dismissed.
now dismissed. Earlier, there was compulsory retirement, then dismissed.
Now this West Bengal Board of Secondary Education, this certificate.
That can be verified, no problem, my lord. That can be verified. That is not the issue. That is not the issue about them. May I place one judgment of the Supreme Court, my lord? In similar circumstances, my lord. In this case, my lord, he completed 25 years of service. Supreme Court says after so long years, he cannot be dismissed or such a way. Two 2019 4 SCC 258 19 4 SCC 258
58.
Vilas Thakur.
Your case is different from this one, sir.
My lord, There also says that my lord,
Your case is different from this one.
here also says my lord, orders are revision. Allegation against discharge or dues a bill car up and the passing department examination.
Manifestly from the materials on record, there has been no suppression or fraud by the appellant in securing appointment. So this board certificate itself.
Under compelling circumstances, my lord, kindly appreciate this thing. He was compelled to bring a 80% certificate only.
Then what about annexure P1?
My lord?
Annexure P1 at page 21.
Yes, man, he failed. That was issued by the board. That was issued by the board. This can be verified, no problem. This can be verified by no problem. This is all right.
Anyway, Ashwin. For the submission of learned advocate representing the petitioner, the learned advocate representing the respondent Union of India is not present. Next date be fixed on 24th of September.
24th September.
You file written notes, sir,
My-
if you want.
My lord.
For filing written notes. Next.
Item number 5 and 6.
I was the appellant, the matter that was disposed to Mr. Rai was for the claimants. Now, from this application, it suggests the original claimant passed away, and there are 6 legal heirs which they have stated in para 2. Now, this is stated on oath, I have no reason to doubt it. But one thing I would like to point it to your lordship,
Now,
the
who
prayer.
has, the LTI is of whom?
Pardon, Malad?
LTI?
LTI. LTI kara.
LTI is the of one. That is Samim Sheikh. The death certificate that are annexed here.
Only thing, if your lordship kindly takes up the prayer, what they have asked for is modifying your lordship's order dated 24th September 2025 by incorporating the names of the heirs in place instead of late Tara Sheikh. Now, only thing, may I just point it out, your lordship's judgment, page 11 of the application, your lordship has directed to disburse the amount to the present claimants. Now, in the present scenario, there are 6 claimants. How and which manner it is to be distributed, that your lordship would kindly reflect in your, because that prayer is not there. Because everybody is major.
The learned advocate representing the appellant Claimant submitted to a filer an application being Can 4 of 2025, which inter alia stated that the appellant Tara Sheikh
Is the injured person.
alias SCIKH Sheikh. Now, who is that another?
And the owner. Tara Sheikh.
had
অমূল্য রতন
expired
ধারা।
on 4/3/2025, supported by a copy of the death certificate marked as Annexure P1. It was further submitted that in the instant appeal, the judgment was delivered by this court on 24th of September 2024. The learned advocate representing the respondent claimant, you are the respondent claimant, sought for a modification of the aforesaid judgment, incorporating the names of the legal heirs of the aforesaid deceased respondent and to direct the You had been the appellant.
Yes, yes, I have the claimant respondent, Lordship.
He also had a court.
No, that appeal has been disposed of.
Appellant Insurance Company to disburse the claim application, disburse the compensation awarded in favor of the respondent claimant to be apportioned amongst the legal heirs of the deceased claimant. Full stop. The department is directed to take note of the demise of the respondent claimant and record the names of the legal heirs as mentioned in the CAN application being 4 of 2025. The judgment dated 4th of September 2020, 4th or 14th?
24th.
24th of September 2024 passed by this court is modified to the following extent. Dito marker মধ্যে the interest accrued on the sum of money deposited by the appellant insurance company at the office of the Learned Registrar General High Court at Calcutta, which was further deposited in the nationalized bank by the office of the Learned Registrar General High Court at Calcutta, is to be apportioned equally amongst how many legal heirs? Six legal heirs being এখান থেকে এই নামগুলো লিখে দেবেন and the sum of interest in accrued on rupees 7,87,800 and the balance sum of interest to be refunded to the insurance company to distinct account paying checks. The other portions of the judgment remains unaltered.
100%.
ওরা কি দুটোর সময় আসছিল?
My lord, item 9 was the appeal of claimants in the morning. My lord was kind enough, my lord, to take it up and fix it up at 2 o'clock. My lord, there is a delay application, and your lordship will kindly come, my lord, to the very last page of the award passed by the learned tribunal, my lord. Page number 47 of this paper book.
Where is the paper book? First of all, let us take the other matters for order.
My lord, since it was only, my lord, with regard to the typographical error correction, your lordship said that at 2 o'clock you come, we will dispose it off.
There are found from the order, lordship. All the date is perfectly corrected. Page 47.
My lord, page 47.
In your memo of appeal. Why have you filed this appeal?
I find out only this issue, the learned tribunal.
Where have you mentioned?
Yes, lordship, only there's issue that the other one, or lordship, kindly page 50.
Did not consider the actual monthly income?
Lordship, I am not.
My lord, he's not pressing that.
Page 50, lordship, kindly come, or to have awarded interest from the date of filing the claim to the date of relation. That page 50. That is the only place. So the date kindly could be corrected. Only nothing more.
This you could have done before the learned tribunal also. For this, you need not. You shouldn't have filed an appeal.
No, lordship, there is some observation of the learned tribunal in paragraph 46 is something and paragraph 47 is something. Is observed that from the date of filing, that is 5/1/2023, it will be 20th
The
March.
learned advocate
I'm
representing the appellant claimants.
Appellant claimants.
Submitted to have filed the instant appeal solely on the ground that the learned tribunal in paragraph no.
No delay condonation prior to that, lordship. I'm
lordship
sorry.
already stated that.
I'm sorry.
How many days delay?
There is the lordship 407 days delay.
400 এটা তো হয়ে গেছিল না?
Lordship already dictated the order delay control.
কে নিয়েছিল ওটা? Yes. এটা নিয়েছিল তো? তাহলে tell me that portion of the judgment.
My lord, page 47, ordered, first paragraph, last line.
Page 47.
Lordship, the ordering portion, first paragraph.
First paragraph.
Last line, my lord. It says that is my lord there, my lord?
Yes, claimant number 1.
My lord,
Mighty.
Yes, lordship.
no, my lord, last line, my lord. That first paragraph, last line, my lord.
Number 2, National Insurance Company is directed to pay the said.
No, my lord, above that. First paragraph, last line. Per annum, 6% per annum from the
3 lakhs each.
lordship.
And claimant number 3, Rajlakshmi Mighty.
Lordship, minor daughter of the deceased.
Along with
Interest at the rate of 6% per annum from the date of filing. My lord, this date of filing is erroneous. This date, numerics, that is wrong.
Should we?
My lord,
28th March 2015.
28th?
20.
Yes, 20 March
2015 till the date of payment.
Yes. My lord,
So only this.
Only this.
Only this is for this you file a
difference opinion of the learned tribunal in the judgment. So I'll not pressing the all. Only this is the issue that I am placing for your lordship. The lordship corrected the date and page 1 lordship will find the date of filing. The stamp is there, 20th March.
Heard the submission of learned advocates representing both the parties. The judgment pronounced by the Judge Motor Accident Claims Tribunal, First Track Court, 2nd Howrah, dated 21st of February 2024. 21st of February
2024.
Is modified in the following, to the following extent. ডিটো মার্কের মধ্যে লেখো এই প্যারাগ্রাফটাকে টুকে দেবে এখান থেকে এই অবধি এটা জায়গায় এটা বলি the other portion of the impugned judgment impugned কি বলবো এটা তো rectification হলো এটা তো judgment and order passed by the learned tribunal remains unaltered.
This line was repeated it one more earlier, in the body of the order also. At page 46, last third line. Since saying the other portion remains, page 46, last third line.
What else to do? This could have done before the tribunal also.
Page 46, last third line. The date is
এখান থেকে দুটো প্যারাগ্রাফ দিয়ে এই যে hence
yes. Hence onwards. Extremely grateful to your lordship.
Any other?
No, nothing. No. Go blessed to my lord.
না এটা order.
Good.
For order, item number 130. My lord, please grant some pass over Mr. Burri just a minute. Court number 6. It is 163 matter, my lord.
Who's your other side?
Onimus, that's the other side. Kindly grant short pass.
133.
I'm for the responsibility. Pass over. 133.
I'm for the appellant, my lord.
Yes.
I have a small submission, my lord. It was heard by you in the next.
Yes, sir. Is it your matter?
My lord, I prepared an appeal only point of income. 15,000 was taken. It will be 3,000 per month. 50,000 per year was taken. Tribunal. It is 3,000 per month. Another is 1/3 in case of injury. 1/3 was deducted. That is not the law, my lord. 1/3 should not be.
Your memo of appeal.
Page, my lord. Judgment. Judgment. My lord. 10.
Accident is of which year?
Yes, my lord.
2007.
2007.
Yes.
And that judgment is of 2009.
Yes.
Only page 15. Medical expenses only awarded 5,000.
6,000
was
awarded for medical expenditure. So what was the exact amount?
Actually 20,000.
You have documents?
Yes,
It was exhibited?
yes, in the evidence also.
Before your lordship proceeds further, I must indicate to your lordship, this is case under section 163 capital A. So your lordship will kindly not go into those details, what was the medical expenses and all. The schedule, your lordship knows, that the notification, notification, is
that he should have told me at the
he should have, since he was not, so I am sorry to intervene, on that ground.
Chanchal kotha gelo?
Your lordship will kindly have a look at this,
Okay.
In this the learned tribunal judge has gone on that basis, awarded 52,000 in total. But this was a fracture injury tibia only. 12-year-old boy who has recovered completely. This is what the evidence says. It says 163A, Urmila Haldar taking note of that, for minor injury, 25,000. And Yes, my lord. Yes, yes, that is why, my lord, I'm showing it to your lordship, my lord. On the last day, my lord, when it was indicated to your lordship, my lord, I told, my lord, I submitted before, my lord, or not honorable court. Lordship. Lordship. My lord, your lordship will kindly come, my lord. The father on behalf of his minors, my lord, is before your lordship. Page 22, it starts the evidence. Your lordship will kindly come to page 26. The evidence of the father. My lord, page 26 is, my lord, is kindly. And my lord, this.
Injured in my son,
Yes.
who is now aged about 14 years.
Lordship.
Come to page 26.
Yes, my lord. Is it about 14 years? 2009. Now became major. He became major.
Sir, you read it. You read it.
Injured in my son, who is now.
I saw the case accident with my own eyes. At present, my son leading normal life.
I'm grateful to your lordship. And the entire case is based upon evidence of a private doctor, Dr. Prashant Kumar Mondol, who has, my lord, opined for 30% disablement without looking, my lord, without asking for any further evidence, my lord, with regard to the extraplates or anything, my lord. This is one simple fracture in the left tibia.
My son has some trouble to lead normal life. Within bracket. My son has some trouble to lead normal life. Normal life হতে পারে না একটা লোকের।
Okay.
My lord, he has already got 52. I'm grateful. I'm sorry.
My lord, this is also an injury case under section 163A of the Motor Vehicles Act.
Who is your other side?
I'm Bharti.
Same matter, same type.
Same type, my lord. Only thing is that this is a gratuitous passenger and award was passed against OP1 and they did.
What was the date of the accident?
Date of accident was 6/10/2006.
Appeal is of 2011. The earlier was appeal of 2009.
2010.
2009.
2010.
My lord.
9.
And there was
Nine.
appeal of 2010.
This is also of 10. FMAT number bolchi আমি।
You have received?
No, this order was passed against
Against the owner of the
owner of the vehicle because gratuitous passenger.
No, owner of the goods are moving along with their
Recover, my
goods.
lord, whatever,
Can
20
recover.
25,000 meager amount pay and
ये ना प्लीज पूरी लो चलो
পরে
135, 136.
আচ্ছা এটার আগে একটা আছে না এই যে 132টা আছে না? ওটা wait,
132.
who is the other side?
This is a case under section 163. Landed tribunal awarded
2004
1,000 accidents took place during the year.
and appeal is of 2007. কে আসবে?
My lord, this is a case, my lord, where the landed tribunal casted liability upon the owner since the victim was the gratuitous person.
No, since there was no insurance coverage. Learned judge.
Kindly see by paper book.
My lord, kindly
that
see.
They have admitted.
Learned
One at a
judge.
time.
Nala আমাকে বলতে দাও। Your lordship, keep my paper book.
Which page?
Page, my lord, 7. This is the written statement filed by the insurance company. They have admitted that the offending victim is
Which paragraph?
paragraph 11.
Yes, then
Then what they respond? Now, my lord, they say that
now you have sufficed his proposition. Now what about you, gratuitous passenger?
gratuitous passenger, my lord, my client is my lord going by a lorry.
Going by a lorry, where is it?
And in the claim application, your lordship,
জাজমেন্টটা দেখি
judgment, your lordship, kindly see.
জাজমেন্টটা বলে দাও উল্টো ডিসিশন উইথ রিজন
And your lordship, kindly see case 13 of my paper book. The Shukendra Mitra was proceeding by the offending bearing number loaded with potato as a helper of the same begin from Mandarhati to Kolkata. That on going to say begin absence with
Who is petitioner number 2?
Petitioner number will be father, the father, the mother and father are the claimants. They claim compensation for the death of their son. Pratima Mitra and Gopal
Now you come to page 9.
Page 9.
I am petitioner number 2. Petitioner number 1 is my wife.
Yes.
I am also deposing in favor of herself.
Yes.
Shukhendu Mitra, whatever, was my third son.
Yes.
He used to work as a helper in a truck. On 13/7/95, he was also employed as helper in a lorry such and such. On that date, that truck was loaded with potato. On that date, my son was going as helper in that truck from when that truck approached near at about on that day, the truck collided with another truck. I do not know.
Everything is stated.
Now, what did the tribunal say?
Tribunal says, my lord, since my lord, the certificate.
Now, show where is the judgment?
Judgment, my lord, your lordship, it starts from page 12 to
page 14, my lord, relevant.
Safely the age. Income.
Per verse.
So for helper is concerned, my lord, learned judge held page 14, my lord, paragraph 3. The owner of that vehicle was also the same village of the petitioner, but PW1 could not bring the owner of the vehicle as witness in this case, so to prove that the disease was really employed by the owner as helper. Therefore, whether he is a helper or not, the owner and the
This was dismissed.
This was
Not dismissed.
awarded against the owner, casted upon the owner. In place of owner, that the insurance company is to make payment and recover from the owner. This is the principal laid down by the Calavaram following the month several decisions subsequent.
That a truck is for carrying articles and it is not for carrying. This was not the helper of the offending vehicle, but nonetheless he voluntarily came by means of that offending vehicles as a passenger. Acha.
He is a passenger, he
Acha, it's not.
My lord, I am placing my lord one paragraph, my lord, page 15. Page 15, last
I have
paragraph.
read it. It is proved that the truck is for carrying.
No, next paragraph, my lord. Furthermore, the petitioner moved this petition so casually that they did not produce the insurance certificate. PW1 also did not state that the offender vehicle was then under
That is there in your written statement.
Therefore, my lord, the LCR require whether the
Yeah.
When I asked you whether it can be fixed for orders, you said yes, right? And now you are saying LCR is required.
whether the insurance certificate is there, learned judge held that there is no insurance certificate. It is learned judge held that why the liability shifted upon the owner.
TCR টা আছে? দেখি।
It has not incorporated with the paper book, my lord.
They have admitted in their written statement that the vehicle is covered by their policy. What else more?
In written statement, so many things stated that this petition is not maintainable.
So why do you submit such written statement which you are also not convinced of? You just write whatever you feel like.
Since my lord, learned judge held that
No, you have only mentioned whosoever was representing your insurance company before the tribunal had submitted certain things. That is what the tribunal has mentioned.
Even column number 17 in my claim.
Tribunal held that there is no insurance policy.
Number. I'm very sorry. I beg to be apologies.
Yes, the chart sheet mentioned the Caesar list. There, the policy of the vehicle is ceased.